Doreen. I think we are ready to get started. Greetings, members. I can see we're about 51 online. And I've been informed by ULS that the president, who was supposed to give us opening remarks, is in another meeting at the same time. So I'll start the session. I think they'll come in at the end of the workshop. I'll start the session by introducing the participants. And myself, I'm Philip Monavi, Business Development Partner at Diadem Advocates. I have a niche and interest in sports law. I'm also legal counsel for Uganda Boxing Federation and a boxer too. On panel, I have Dev Kumar Pama, Principal Director Pama Sports International. He's a writer, he's a lecturer and CAS practitioner. He'll be handling our first two topics, which are the key sports law concepts as conceived in national and international law. The second topic will be emerging challenges in the sports scene and legal practices. Our second panelist will be Brian Kajubi. Brian is a renowned IP and sports lawyer. He lectures sports law at the University of Uganda Christian University. He's also an associate partner at Max Advocates. Then we shall have Ivan Ojakol. Ivan Ojakol is a renowned columnist with the Daily Monitor. I think he has been writing for the last 6 months or so. He has an article in the Daily Monitor on sports law, sports and the law. Ivan Ojakol is a partner at Matrix Advocates, a very dedicated team of young lawyers. He lectures at the International University of East Africa. He had this very week, he had a very nice session on technology and the law, which was highly attended. He will be handling an assessment of the national sports laws. You'll all realize that we have the national sports bill and the physical education and sports bill that are into Parliament. I've seen in today's New Vision on page 12, there's a public notice that the National Sports Bill 2021 was read for the first time on Wednesday 9th and referred to the Committee on Education and Sports for scrutiny. So there's a call for stakeholders and interested people to contribute to the National Sports Bill. Ivan will be taking us through the laws as they are, the bills vis-a-vis the National Sports Act, National Council of Sports Act 1964. Then Brian will handle, he has a good presentation on the Court of Arbitration for Sports and sports dispute. His topic is sports disputes, the nature and character of sports, courts, and the Court of Arbitration for Sports. I welcome Dev because he has a flight immediately after this session. He has dedicated his time. It is around 6 where he is, but he has been willing and ready to present to us. You're welcome, Dev.
Thank you very much, Philip. Good morning to you all. Thank you all for your attendance and your participation today. First of all, just for sake of housekeeping, Philip or someone else from ULS, can you just confirm, am I audible? Is everything clear?
I can confirm from my side that you're clear.
Excellent. Thank you, Philip. And thank you also for highlighting. I do apologize to you all in advance. My part of this session is going to be slightly rushed because, as Philip mentioned, I've got to fly out. Funnily enough, Philip, of course, with your involvement in Uganda boxing, I've got to fly to Abu Dhabi for the the International Boxing Association Congress, which I'm going to be partaking in tomorrow. So that's why I'm rushing. And also because of that, I will have to get through my sessions almost in bullet point form, but that doesn't mean to say that I don't invite participation or interaction at any stage. So with the leave of the ULS, if anyone's got any questions at any point, please don't hesitate to put them forward, either by way of the chat or by way of unmuting yourselves if you've got the ability to do so. And finally, despite my rush, please let it not take away from the fact that you've got two fantastic presentations from eminent professors after me, from Mr. Ivan Ojakol and of course Mr. Brian Kajubi, who I know very well. So I hope that this session proves fruitful for you. And we'll start off, if I may, just speaking about some new developments within the sports law sector. And for the limited time that we've got speaking about this area, I'm going to focus on the proposed regulations by FIFA. So we'll narrow down into the sport of football. The proposed regulations by FIFA for agents within the industry. Now, I express that these are still proposals. They've not been approved by the FIFA Council, and therefore they are not they're not in force yet. We don't have a clear date as to when they're going to come into force. However, there is a drive by FIFA to have these rules in force for 2023. So I'll briefly outline where we are at the moment and what changes we expect to see. So if it's all right, may I share my screen? Don't know if I've got the ability to do so. Right, is that visible?
Yes, Dave, it's visible.
Excellent. Thanks, Philip. So, as I mentioned, we're going to speak very briefly about the new agents regulations and also something called the clearinghouse at FIFA, which many of you who are in practice, whether in sports or not, you can probably figure out what we're referring to. But this is a breakthrough situation in the world of sport. It's something that FIFA has been ideating for a while. It's actually following up from something that goes on at the English Football Association anyway, with regards to clearance of money and authorization and oversight of transactions in football between clubs in England. So FIFA has now implemented it at a world level. So I'll explain to you very briefly how this has all come about. So the aim of this short session is just to provide you with an overview of the current rules around intermediaries in football. And I'm going to interchange between these two terms, but it's important that I do so. Again, some of you may know exactly what I'm talking about. So in that sense, forgive me for any repetition. But for those of you that are not fully au fait with the system, it's quite important to understand these minor distinctions, because from a FIFA perspective, there is currently no such thing as a football agent. That does not exist. The term does not exist. So the casual reference to someone as a football agent is actually de facto, from a regulatory perspective, not correct. So it's just important to be clear about what we're referring to. We're referring to intermediaries, what an intermediary actually is, what intermediary activity is, and then what sort of change we anticipate when we go back to the agent system. And then, of course, going back to formally referring to these actors as agents themselves. So we're just going to carry out a short overview on the current situation, the proposed situation, and what we expect from the clearinghouse, which has just come into force, but is not active as yet. Because again, for those of you that follow the world of football, the transfer window in most countries has not yet opened, and therefore the actual use of the clearinghouse has not been something that has come into play. There have been a number of tests that have been taking place. We've been very thankfully invited to be involved in it and to get some of our club clients from different jurisdictions involved. But as yet, the clearinghouse is still not fully operating. So at the end of the session, I'm hoping that you'll understand the situation a little bit better. Right. Let's start off talking about why we use third parties in football. Now, it might sound quite obvious. It might sound self-evident, particularly for a virtual room full of lawyers, that where there are transactions, where there are contracts, there is the necessity for legal counsel to be involved. But the reason why I mentioned this at all is that in the world of sports, specifically the world of football, there is often this tendency to do things by oneself. Now, that in itself is not something that I would necessarily condemn. The interest and the ability for people to handle their own affairs is something that is not only restricted to football. This happens everywhere around the world. But from a legal perspective, it becomes quite challenging. And in football, we often find that players, agents, club officials, when it's convenient to them, everyone seems to be able to become a lawyer. This often leads to them doing their own DIY, for want of a better term, and this DIY leads to issues. Now, the current system that we have in play around the world does not cater to disputes being resolved. There is no central dispute resolution mechanism. There are some dispute resolution mechanisms in play within different countries, but ultimately, if an issue arises during intermediary activity, let's say, for instance, there is a dispute around commission that has to be paid for activity where an intermediary has represented a player that has signed for a football club, and the club hasn't paid the intermediary his or her fees. There's no central mechanism for that dispute to be resolved. It might be, depending on how the agreement has been drafted, it might be that dispute could be handled at the state courts in Uganda, or at the state courts in Italy, or at the state courts in Bolivia. However, you can imagine, and you can see the impracticality of this, particularly where we start to have actors that might be cross-border, and there might be the ability for the player to move internationally thereafter. The speed with which one might go through a national court system is not desirable. Furthermore, if the enforcement needs to be made not at club level, but an enforcement needs to be made against the player who's moved from Uganda over to Tanzania, from Tanzania over to Egypt, the enforcement is going to be another concern, because by the time you've finished a court case in 2 or 3 years, the player's moved off to a different continent. So what we used to have at FIFA, prior to these regulations coming into force on the 1st of April 2015, what we used to have at FIFA was a central dispute resolution mechanism that enabled agents, and they were agents at the time, it enabled agents to be able to take disputes over to FIFA and have these disputes handled, have decisions awarded in these disputes, and then for participants to be able to enforce these decisions through the FIFA mechanism. So if somebody does not comply with the decision, then FIFA has got the power, through the fact that it's signed in to these clubs being members of member associations that are members of FIFA, or the players are participants and they're registered to the Football Association as well as being employed by the club. One way or another, FIFA was in a position where it could enforce these decisions by applying sporting or financial sanctions, effectively stopping people from playing, or stopping clubs from participating, or diminishing their success by penalizing them with point sanctions if payments weren't made. That was all scrapped when the current regulations came into force. Now you can understand, I hope, just from that very brief explanation, why it's even more challenging to have people within football do things on their own without legal support, for agents or intermediaries to do things on their own without legal support. It causes absolute chaos. Disputes are around all the time. And frankly, we, and I say we as lawyers, are in a position where there's very little we can do from a reactive perspective. We still have in our practice every week agents, in the plural, coming along, contacting us, saying that they've got an issue with unpaid commissions or such like. And unfortunately, because they've not been proactive and drafted their contracts appropriately, incorporated CAS clauses, something that Brian Kajubi is going to speak to you later about, no doubt, incorporated CAS clauses into their agreements, there's very little route that they can use to resolve their disputes. And it's not attractive for a number of reasons for them to go to the state courts in England or the state courts in Spain or wherever else it might be, because it's often cost prohibitive and it's often far too long before a decision can be rendered. So we look at some of these issues, and this is why we have to use third parties in football. Now, as I mentioned before, we need to separate very briefly the terms. Prior to these current regulations, they used to be called, or these actors used to be called, agents. Now, colloquially, they are still referred to as agents, but according to the FIFA regulations, there is no such thing as an agent. Now, this is something that often brings about challenges in many different countries, particularly for people that have been previously licensed and they've still got business cards which say, I am a FIFA agent, I'm a FIFA licensed agent. Well, with respect, you're not, because there's no such thing as a FIFA licensed agent. What one can be now is they can become an intermediary, and that intermediary would be registered by the local association. So with yourselves, it would be an intermediary licensed by FUFA, or in England, an intermediary licensed by the FA, or in Spain, an intermediary licensed by Real Federación Española de Fútbol, and so on and so forth. Now, an intermediary is defined by the regulations on working with intermediaries as a natural or legal person who, for a fee or free of charge, so even if it's pro bono activity, represents players or clubs in negotiations with a view to concluding an employment contract, or represents clubs in negotiations with a view to concluding a transfer agreement. So intermediary activity is something that can be done for a fee, or it can be done for free. It's not simply contingent on there being money involved, right? Sorry, an intermediary is a person, not intermediary activity. Intermediary activity itself is undefined, but it's usually defined at member association level. So it may or may not incorporate some of the terms in the definition that I've put down over here, whereby an intermediary would be engaging in activity if they're directly or indirectly representing a player or a club in relation to any transaction. In effect, I'm not going to read out the entire passage for you, but that's just to give you an idea. It's quite broad. In theory, it can cover many different things. Now, the reason why FIFA let the member associations define activity themselves is because the laws will slightly differ in each jurisdiction. We saw a huge controversy when FIFA enabled all the member associations to do things themselves, to have their own autonomy in this area in 2015, because some countries still had a strict law with regards to agency, such as France, for example, even Belgium. You can see immediately there a connection. Francophone countries with a Francophone inquisitorial legal system. FIFA has got 211 member associations that it oversees. Now, if you think about how vast that is, you can see some of the issues that will arise. There are only 192 signatories to the United Nations, and FIFA's got 19 more bodies than the United Nations itself. So you think about the number of jurisdictions that it's got to deal with, and the idea of having a universal oversight. So when it enabled all of the member associations under its umbrella to be able to do its own thing, it still had challenges, because in France, the law of agency is particularly strong, is particularly prominent. So FIFA doing away with a central license and enabling people to become an intermediary without having to take an exam was contradictory to French law. So in France, you've still got to take an exam and you've got to become an agent under French law, and then you can have your accreditation accordingly. And similarly in Belgium, and then some other countries have taken up the exam process, not necessarily because of their local legislation, but also because they wanted to make the process of refinement more difficult. So when the centralized regulation was scrapped, and as mentioned, the examinations were scrapped, the vast majority of member associations enabled people to become intermediaries following a very simple process. And that process is pretty much as I've put down here on the slide. You make an application, and that application could be as simple or as complex as the member associations want it to be. But the example in England or the example in Spain is that you make the application essentially within 5 minutes. You fill out all of your personal information, you put your address, your date of birth, blah, blah, blah. Make the application, you submit, you make the payment, you declare good character by ticking a box online, and you're good to go. It's as easy as buying something on Amazon. In Spain, there's another added value in that you've got to go and have a one-on-one personal interview. That interview lasts on average about 5 minutes. And then, of course, in certain countries, it gets progressively more difficult. But it's fundamentally different to what we used to have several years ago, which was one had to go through an exam and obtain a formal license, go through a process of refinement, which is no longer in existence. So in addition to there not being an examination process, the regulations on working with intermediaries that are currently in force made a number of different changes, which again caused chaos. So there was no maximum duration of contract between a player and an intermediary. Now, this is something that has often been regulated over the last few years by the laws of the member association. But in theory, if a particular country does not have statute or does not have jurisprudence, whatever the system might be, to be able to dictate a limitation on a contract, then in theory, a contract between a player and an intermediary in that jurisdiction could last forever. Furthermore, No mandatory requirements for liability insurance. Again, this is something that has been dictated at member association level to a certain extent in Brazil when these regulations came into force, in accordance with Brazilian law on agency and this kind of activity in general, football or otherwise. You had to have actors that had their own insurances. So with CBF, which is the Brazilian Football Association, their rules added the element that one has to be registered with their own insurance. Otherwise, they will not be able to obtain a license. This is not mandatory in England. It's not mandatory in Spain. It's not mandatory in many other European, Asian, or African countries. But this, again, was another change. So we're currently in a situation where, in theory, the contract doesn't have to have a limitation. The actor doesn't have to have any liability insurance. They cannot, however, receive any money for work done representing minors whilst the player is under 18. And furthermore, any commissions that they seek to take should not, I emphasize that, should not supersede 3% of the gross amount of the employment contract or the gross amount of the transfer. Now, again, this is the current state of play. Some countries took this 3% as a hard cap and they enforced it within their own jurisdictions. Some have then changed that. Italy, for instance, started off with a hard cap of 3% and then amended that over time. The market practice tends to be between 5 and 10% for commission payments, either from a player or from a club. What we tend to find in less developed football economies in some parts in South and Central America, some parts of Africa, some parts of Asia, some parts of Central and Eastern and Southern Europe, is that the practice would tend to be something more like 20% or even more in certain instances. It's not appropriate, but FIFA can't stop it. And unless there is a hard cap, which is governed by the legislation within that same country, the member association can't stop it. So it happens. So you can see, I hope, that we're currently in a situation that is an absolute mess. Many people have referred to this as the Wild West. Okay. And furthermore, it's been exacerbated by the fact that FIFA removed its own jurisdiction. So as I referred to previously, the ability to take disputes over to FIFA, to its judicial bodies, and have a decision rendered was scrapped overnight. And all of a sudden, it was a free-for-all. From FIFA's perspective, it was very much a case of, we have 211 member associations. We invite you all to handle things locally. We've given you the tools, we've given you the guidelines. We are going to enable you at FUFA, at the FA, at FIGC, at Real Federación, at FFF in France, and so on and so forth, COSI in Iceland, all of these football associations. We're going to give you the ability to handle disputes yourselves. I'm sure you could all appreciate that in practice, that seldom happened. And 7 years on, out of the 211 member associations, there's probably a handful of associations that have got effective and working dispute resolution mechanisms. So that means that 90% of the footballing world is, again, just running around in a chaotic situation. So what we did say, or what I touched upon earlier, and again, I'm hoping that that Brian might also latch onto this when he speaks about CAS. One of the routes for agents to be able to protect themselves in their own activity was to incorporate a CAS clause into their agreements. And again, for those of you that are not followers of sports law, I'll just split up the acronym. CAS stands for the Court of Arbitration for Sport. It's also referred to in some jurisdictions as TAS, which is the Tribunal Arbitral du Sport in French. But essentially, it's the same thing. It's CAS/TAS or TAS/CAS. Now, the CAS is often referred to as the supreme body, legislative body, or judicial body, I should say, within the sporting world. Whenever you have a major sporting dispute taking place, it often goes to CAS. We've literally just had, I don't know if any of you have heard of it, but in the world of Taekwondo, we've had the two American Taekwondo players have just been exonerated. They've had their life bans overturned. They had been banned for several years for alleged sexual offences, and those bans have been overturned just yesterday, and that was dealt with by the CAS. If anyone followed the Winter Olympics, you might have seen the situation with Kamila Valieva, the figure skater. You might hear about doping issues quite frequently with athletes or players or fighters or whatever else it might be, and this would all go to the CAS. So when we're talking about the CAS, we're talking about the absolute pinnacle, where an agent wanted to protect his or herself and any transaction they had been involved in. What they could do, and what we tend to advise, is that they draft CAS clauses into their agreements that they sign with players or agreements that they sign with clubs, so as to be able to ensure that if they are owed an amount of 50,000 USD or whatever else it might be, and they do not receive these payments, they can launch a claim at CAS accordingly. Now, going to CAS, in theory, is going to be far more attractive than doing something within your member state, simply because of the speed and the efficacy of CAS, as opposed to taking your sporting matter through a normal court system. And in addition to that, the understanding of the situation, the sporting specificity, as has been referred to quite frequently in the sporting world. Furthermore, the ability to enforce universally. Now, the Court of Arbitration for Sport is underpinned by the New York Convention of 1958. And for those of you that follow international law and international arbitration, the New York Convention of 1958 effectively designates what is globally recognized as an international arbitral tribunal. And it enables decisions from these arbitral tribunals to be enforced within any country that is a signatory to the New York Convention itself, of which there are, I don't know the exact figure now, I think there's 160 odd, but basically the vast majority of the globe is covered by the New York Convention. So if you take a matter over to CAS, as opposed to trying to take it through the English courts, you're guaranteed, again, in theory, there are always ups and downs, but you're guaranteed to have a situation that is dealt with quickly by arbitrators that understand the sporting context. And when a decision is rendered, if the dispute is against a player that has moved to another country, or you are in another country to the club that you're actually dealing with, for instance, you're able to enforce that decision without necessarily having to engage a local lawyer and having to go through the local courts wherever the assets of the respondent might be, because CAS works in line with FIFA and it taps into the entire FIFA ecosystem. So this is one thing that we discuss, but a lot of agents are not aware of this. So when I mentioned right at the start, we still have agents coming along to us asking us to help when they are owed 10, 15, 20, 30, 100, 200,000 euros or USD, but they don't have a CAS clause written in. Oftentimes, they don't even have governing laws written in, which is absolutely absurd for a contract, but usually because they've done them themselves. And they've got no body or no jurisdiction within which they can actually take these contracts forward and enforce them. So they just lose money. Previously, even if a contract was poorly drafted, FIFA would be able to take it on. Now, that's not the case. So I mentioned already that in theory, anyone can become an intermediary. So I'm just going to scan through this very quickly. And let's move on, if I may, to what the proposed rules are. Now, the proposed rules have been the proposed rules for about 2 years already. They were supposed to be signed off at the last FIFA Council meeting, which was in October this year, a couple of months ago. It was delayed. It was October the 28th or something like that, if I'm not mistaken. It took place in New Zealand when most of the member associations had gone over in preparation for the Women's World Cup taking place in Australia and New Zealand next year. Everything else on the agenda was signed off apart from these new proposals, because as always, there are some controversies. The hope is that it's going to be signed off by the end of this year, which leaves us with very little time. There's only a couple of weeks left. And if that does happen, then they are likely to come into force for July 2023, which will be the summer transfer window in the European calendar of 2023. What FIFA is looking to do now, and why this is quite pertinent, is that where FIFA 7.5 years ago had effectively dispensed with the entire agent system and left every member association to its own devices, now FIFA has realized the chaos that was caused and has decided to pick it up again. FIFA has said that they're going to take up the regulation of agents again. It is going to be referring to these actors as agents again. And in order for someone to become an agent, they are going to have to go through a process of refinement again, like they used to previously. So the first thing we're looking at in terms of these actors becoming agents is going through an examination process, which will be centralized and governed by FIFA, although dispersed through member associations. There will be a centralized process. This is something that is almost universally agreed and therefore sits quite uncontroversially at the moment. There will also be further eligibility requirements. So I mentioned to you briefly that to become an intermediary at the moment, in many jurisdictions, the only thing one has to do is to tick a box online to say, yep, I'm of good character, I've got no convictions, you can give me a license, effectively. Now, this is going to be tightened up. This is going to be something that will prove controversial to a certain extent, because again, each different jurisdiction will have differing laws with regards to how someone can be eligible to partake in this kind of activity. It may be that the local company laws come into play and we try and have a definition akin to what might be appropriate for someone to become a company director, or what might bar someone from becoming a company director, for instance. But the aim is to have stronger eligibility requirements, and furthermore, specific obligations will be placed on these agents in order to ensure that they act in the best interests of the client at all times. Now, again, this might seem something that is self evident. However, at best, it's usually only ever an implied term. So there's going to be an expression in the licenses of all of the agents to ensure that they are obliged to act in the best interest of the client. And if it can be demonstrated that they did not, then it might be that they have a suspension or a disbarring of their license in entirety. Furthermore, and this might come of interest, it might also appear peculiar for you legal minds out there, there is now going to be a restriction on multiple representation. As it stands, tripartite representation is still not a breach. Now, in most instances, and I'm sure the legal minds out there will be screaming through their screens, tripartite representation in a singular transaction inherently builds up conflicts of interests. It's normal. It's something that you can't get away with. However, in football, it's something that has been going on for the last few years. And I'll give you one very quick example. And again, for those of you that don't follow football too much, do forgive me, but I hope you'll still be able to take an idea from the example I give you. Now, the late Carmine Raiola, who passed away last year, Carmine Raiola, or this year even, in fact, was often referred to as a super agent, one of the most famous football agents in the world, football intermediaries, I should say. He was the representative, and his company still is the representative, of a football player called Paul Pogba. And I'll expand upon it in that way, specifically for those of you that are not followers of football. But Paul Pogba was a huge player, massive profile, one of the most famous football players in the world, has represented two clubs in his professional career, Manchester United Football Club, the most famous football club in the world, de facto the largest football club in the world, irrespective of its competitive strength or prowess at the moment, but with regards to reach, fan base, ability to commercialize, you've got Manchester United, then you've got Real Madrid and Barcelona Football Club in Spain, and then you've got many of the others. So Paul Pogba represented Manchester United, then he also represented, and he now again represents, Juventus Football Club in Italy. Now, when he moved initially from Juventus to Manchester United, and he's now actually gone back in the reverse order, in 2016, his intermediary had managed to engineer the deal in a very interesting way, where he represented the player and had an intermediary agreement with the player, with Paul Pogba. He also represented Juventus, the selling club, because when he took Paul Pogba to Juventus, the arrangement was that he would be the sole person, the exclusive person, to handle the sale of Paul Pogba's registration as and when it happens. So he represented Juventus, and he represented Manchester United by saying to Manchester United, look, I represent Paul Pogba, I also represent the club. If you want the player to join you, you've got to come through me. So he had the ability to sign an agreement with Manchester United as well. Now, the total transfer in pounds was around 89 million. And that included everything that Manchester United had to pay. It wasn't just the amount that went from Manchester United to Juventus. Out of that 89 million pounds, due to all of the representation agreements that Carmine Raiola had in his pocket, Raiola was reported to have achieved around 40 million. So when I was referring to commissions earlier and talking about the recommendation of 3% and the market values often being between 5 and 10%. And in some jurisdictions where it's not actually working as effectively as it could, or in less developed jurisdictions, sometimes you get 20 or 25%. In the biggest transfer in the world at the time, the intermediary received, what's that, 40%, 45% of the entire transaction. And that was because of multiple representation, tripartite representation. So this is something that is now going to be outlawed in the new rules. At the moment, it's still going ahead. Now, there are a number of discussions that can be had with regards to how effective it is and whether it works at certain levels of the market. It was possible at that level with that elite profile because of the scarcity of that kind of talent and the desire for Manchester United to have that talent within its team. It's not necessarily something that an intermediary is going to be able to do in the second division of professional football in many different countries, because the level of talent that you're dealing with there, whilst elite, whilst professional, is still very replaceable. It's not a Paul Pogba or a Zlatan Ibrahimovic or a Lionel Messi. It's someone that, with respect to them, if they don't join, we can find another 10 of them tomorrow. So these are certain practical things to consider, but from a legal perspective, this is now going to be outlawed. And the way in which the commissions are going to be handled by FIFA, they're still going to use the 3% figure, but it's now going to be a hard cap as opposed to a recommendation. And it's going to be 3% for each party. So the agent will be able to represent the player and the club and take 3% for each. Now, this would be 3% of the gross remuneration, which could include the salary or the signing on fees, but not include any amounts that might be received for use of vehicles or accommodation or anything along those lines. Furthermore, with regards to dealing with minors, this is, of course, one of these things that is particularly important in football, because the growth of a football player is something that is keenly followed, and agents want to start taking players into their stable very, very early, often waiting until the age of 18, until the age of majority in many countries, is not good enough. It's not good enough because some players have already started to be able to monetize, and you want to try and jump onto that train as early as possible. This leads to a number of challenges. It also leads in some instances to trafficking players into different countries. And these are all issues that are probably outside the scope of this discussion just due to the lack of time. However, what FIFA is going to propose now is that the approach to a minor is restricted to no longer than 6 months until they are able to sign a professional contract. So if that particular country, like for example in Croatia or in Bosnia, that country enables a player to sign a contract when they are 16 years old, then you can only approach that player as an agent from the age of 15 and a half. If it's 17, as in England, you can only approach them from the age of 16 and a half, and so on and so forth. Of course, like in many countries, minors must have their contracts signed by a legal guardian as well. However, the ability for an agent to formally go and take a player on at the age of 12 or 13 and to try and follow his or her career all the way through is going to be restricted. Now, practically, it still happens. There are academies around the world that cater towards this, but from an agency perspective, which is going to fall under the ambit and the jurisdiction of FIFA, you are not going to be able to do this until there is only 6 months left before the player can sign his or her first professional contract. Finally, and again, it's been whistle stop, what we now have is a clearinghouse. So we have a centralized payment system. The FIFA clearinghouse is set up in France. It was officially opened by Emmanuel Macron, the president of France. And again, it's up and running. It's been tested. It works, allegedly. But we are still waiting for the real activity to come into play when the new transfer window will open. The aim for the clearinghouse is to process and sometimes to automate payments between clubs. The clearinghouse will, over time, be extended to agents activity. So where agency commission comes into play, that can then be handled by FIFA rather than simply being a transaction between a club and an agent, or a player and an agent. The idea behind all of this is to promote financial transparency and integrity. Invariably, as many of you might be able to imagine, if there's a clearinghouse that at any given time is holding millions and millions of pounds, euros, dollars, shillings, rupees, whatever it might be, then there's always going to be another avenue for the owner of that clearinghouse, or the owner of that account, to be able to increase value and to monetize. So without looking at it too purely, there is definitely a business element there. However, there are a number of positives, because the clearinghouse should be in a position where it can streamline payments between clubs for training compensation and solidarity mechanism, which again falls outside of this discussion. But when it's opened up to agents, it can tie in with the football tribunal, with the judicial bodies at FIFA, and ensure that first, payments are made effectively. And if there is a situation where payments are not made effectively, then within this combined system, the agent can take a dispute forward, have a decision rendered in a swift manner, and then be able to enforce that decision within this entire ecosystem. Going back to what we had theoretically a few years ago, but an improved version of it, and going forward into a normal system where if an agreement is made between two or more parties and a dispute arises from that agreement, the aggrieved or the injured party has got the ability to go forth and to be able to render a claim and handle their dispute. This is not football talk. This is not FIFA talk. This is normal. It happens everywhere in life all around the world. But unfortunately, for intermediaries at the moment, it's not something that is available to them by default. That should, I hope, change in the coming months. So with that, Philip, and to the entire Uganda Law Society, I hope that I've briefly put forward, and clearly I hope put forward, the current situation with intermediaries, what the proposed changes are when we go back to the agent system, and this new clearinghouse that has come into force, and how that should all tie in with each other. We could expand upon this in a lot of detail, and we could cover it in several hours, but as a whistle stop, I hope that's all been clear and of assistance. And of course, any questions about this or about our working experiences, I'm completely open to them and at your disposal.
Thank you, Dave, for that timely presentation. It's really been on point. Maybe my takeaway, my question would be on the removal of jurisdiction, FIFA jurisdiction, because locally here, the FIFA has its dispute resolution chamber, and so many decisions have been made on players, more so on ethics and discipline. How does it work where FIFA has no jurisdiction over matters concerning the sports fraternity internationally. Secondly, I'll also invite in, I know Ojakola has been so passionate about this agency topic. He thinks that the agents are not happy at all. He'll also chip in something as we wait for some questions from the chat room. Please feel free to bring in any questions that you may have.
Ivan, are you going to go now?
Oh, thank you, Philip. Well, for me again, Dev being our senior in this field and the professor, the real professor, as we are still aspiring professors, I would just like to inquire what has been the reaction from his clients, and I also know he also does some agency work, I believe. How has the market? Yes, it's still haven't signed the regulations yet, and they have not yet come into force. But how is the market feeling? Because I know, for example, the agents in Uganda that have interacted with are really, what should I call it, scared and worried about their business as far as this is concerned.
Well, thanks, Ivan. And Philip, I'll go back to, if I can, I'll deal with Ivan's question and then I'll go to your question in that order. So I'll go in reverse. Ivan, the reaction has been interesting. Very, very interesting. Now, you mentioned me doing agency work. I used to do agency work. I don't operate as an agent or as an intermediary anymore. We haven't for some 5 years. Our practice focuses quite a lot on representing agents, but in that sense, we're still involved in the market. We have to handhold agents from stage one of a transaction right through to completion, and that often involves doing all of the negotiation on their behalf as well. So we're still involved in, let's say, a slightly peripheral manner, but I don't sit as an agent. And in that sense, I've got, thankfully, no particular concern, if that makes sense. I'm not impacted by it either way, because we're there as legal counsel and we'll just represent based on whatever the rules and regulations are. But I think the general proposals have been, I think we can divide it. Almost everyone has been happy that there's going to be centralized jurisdiction again. I think that's the first thing. Almost everyone we've come across has been happy that there's going to be a more formalized licensing system. Now, this is caveated by the fact that many people who are already licensed don't necessarily want to go back to square one, let's say, and have to do an exam if they've been appearing as an intermediary for 4, 5, 6 years. If prior to the intermediaries regulations, they had already taken a FIFA exam in 2010 or 2008 or whatever. So they don't necessarily want to be in a position where they've got to go back to square one, pay more money, do another exam, potentially fail an exam, which would then stop them from doing activity that they've been appropriately doing for the last 5, 10, 15 years. So I think there is a caveat there. But overall, the idea of FIFA taking this under its wing again has been welcomed. Now, in our experience, where the challenges come into play, as Ivan, you, and I'm sure everyone else on the call could imagine, is usually when we start talking about money, right? This is pretty much when all the disputes start to arise. So the first major controversy we had when the current regulations came into play in 2015 was this 3% situation. And when the emphasis was on 3% only being a recommendation, quite quickly, a lot of these concerns were quelled, unless you were operating in a member association like Italy, where it was a hard cap of 3%. Here, we are now going to have a hard cap of 3% per party, which would effectively mean that you maximize as an agent, you maximize at 6% if you're representing both the player and the club. FIFA's argument is that this is above the standard market rate of 5% anyway, and therefore it's generous. A lot of the agents that are against it, many agents bodies, the Africans Agents Association, the Association of Football Agents in England, AFA, the European Football Agents Association, FAB, all of these other bodies that we have around the world, which unfortunately haven't got any unification, but all of these bodies around the world are basically saying that there's a restriction of trade here, a restriction of trade in many senses, and a restriction of the ability to freely earn money. There are questions as to whether the FIFA regulations are going to comply with European law or not. FIFA is adamant that it is in compliance. However, there is already a class action that is brewing, just waiting for these regulations to formally come into force before it kicks in. So I think to answer your question in, I hope, a complete way, Ivan, the reaction is interesting. I think the reaction generally is quite positive to certain aspects. The ability to be able to handle disputes at FIFA, the ability to be able to work in a recognized industry, to have peers of yours that are recognized and licensed appropriately, for there to be stronger eligibility requirements. I think all of this is generally welcomed. When it comes down to money, that's where we start to have the issues again. Ivan, I hope, does that answer your question?
Well, thanks. Yeah, it does, Dave. Thank you very much.
Dave, I see a hand by Dennis Lukambi. Dennis Lukambi is the head
He's
legal.
my good friend.
He's the head legal of FUFA. I think he has a question. Dennis, please put on your mic and ask the question. Dennis, I hope I'm not losing you. But in the meantime, there is a question from Kaja Timothy.
From Timothy, yeah.
In the clearinghouse that you mentioned, that is not yet operational, yet it could have been launched on 16th.
It was launched last month. Yeah, indeed. No, thanks, Timothy. It's good to interact with you again, as always. And forgive me if I didn't articulate it appropriately. It's launched, it's up and running, and it's been tested. So as I mentioned briefly earlier, it's supposedly working, and we were very honored to have been involved in that process, where we actually had to compile a number of our clients in different jurisdictions. We recommended 3 football clubs in Africa, 3 football clubs in South America, and we recommended 1 in Europe, and then there were a few others that were coming from different sources who all took part in the testing. So in that sense, yes, it's been launched, it's open, but it's only really going to be tested when the new transfer registration period, or colloquially known as the transfer window, opens up. And in most countries, the winter transfer window is not open as yet. So that's when we'll see transactions going back and forth, and then money, of course, having to be exchanged, and the clearinghouse having to be, let's say, used. We've not seen that as yet. We've only seen the pilot tests, if that makes sense. I hope that answered the question, Timothy.
Dennis, I need to hear from you. Please ask your question, because we need to get into another session. See.
I think Dennis, Philip, if Dennis is unable to log on, I'm sure he's going to be burning up my WhatsApp later on with the question. So I'll be looking forward to hearing from you one way or another, whether it's on this platform or whether it's privately later on. But it's good to have you on the call.
Thank you, Dave. Yeah, as more questions will be coming in, I've seen a question from Max Inarulia, but we shall come to it. Is Brian on call? Brian has a short presentation that he wants to make because he has another meeting at 11. I wish to call him on.
Yes, Philip, I can hear you.
If it's fine with you, I think you can present, then Dave will come in because he's still in his time. He will come in after you.
Okay, I'll be delighted if you could also throw more light since he's on the CAS practitioner and arbitrator. He will do more some justice to this topic, in particular sports arbitration.
Thanks, Brian. I'll just unshare my screen so that I can enable you.
Okay, thank you.
Brian, do you want me to share your screen or you're going to share it?
Help me display my presentation. Where I am, I'm using a phone and I was in motion. I just parked somewhere. So if you could help me, please, if it's possible to display it as I present. Yes, a blessed morning, everyone. It's an honor to share a platform with my senior, my former trainer, lecturer in sports law. The last time IOC organized sports law session and practice for different delegates, I think it was 2019. I was lucky to have been trained by Dave. And I will use some of the knowledge I probably got from Dave to share with everyone on this call. Once again, I intend to remind everyone on this call that I will try as human as possible to minimize the legalese in as much as it is sports and the law or sports law. Actually, the spirit of the law, or rather the spirit of the game of the sport, is against the strict application of the law, which we normally call lex ludica. So I'll try where the law actually is applied. We shall go by the spirit of the law. I've shared, or later on we shall share the slides, but I'll go through them in a very summarized approach, just to tackle the key concepts or key principles. Some of us who are new to this concept of sports law or sport and the law, we keep on wondering, what is this thing called sports law? I'm sure one of the presenters, OJ, and even my senior Dev, they'll hint on this. I may not have time to go through it. Probably could have been by way of a brief background to it. Of course, you hear a sports law practitioner, people wonder, what is it about? Of course, the challenge for the sports lawyer is simply to explain what is so special about sport and the law, and probably why it is important that in so many occasions, it is treated differently by the law. When you compare other legal regimes, the one to do with the sports, or the sport and the law, is somehow treated differently by the law, but we shall get to that. So world over, every sports law practitioner, enthusiast, or any bit even a general arbitrator or a practitioner in law. The interest is not that you go somewhere and they teach you mainly about sport. It's a relationship between the industry of sports and the different bodies of law. Could be tort, could be intellectual property, it could be antitrust law, contract, employment, etc. So this is the reason as to why it has become such an important and popular field of legal study in the recent years. Many people have just realized that actually in sport, the law plays a very, very key role. My brother Ivan normally educates the public about that in his usual column. Now, I want to highlight a few things before I go into the gist. To talk about the increasing importance of sports law and sports disputes. Now, one of the most important recent developments in sports law and practice, as you'll agree with me, has been the growing sophistication and what we call the technicality of the jurisprudence of specialist sports tribunals. The key word I want to emphasize is specialist tribunals. Just like we have tribunals for tax disputes, and other bodies. So because of that, jurisprudence has been growing in sports disputes by virtue of the established specialist sports tribunals and appeals panels. We have seen in most cases, by way of analogy, that some of these bodies acted almost with exclusive jurisdiction, it has been challenged. For example, to do with disciplinary procedures, hearing of cases, and in most cases, some of these cases are heard and determined by people with detailed knowledge of the law, and the determination of those disputes has been with specific legal issues that have been resolved, nothing outside. So the legal issue still is limited to the context of sports, as we shall see later with the nature of CAS. So I'll go straight to the presentation. I'll go through it very fast. You can go to, I think, slide number 4. Yes, thank you. I'll take you through the general introduction, the background to CAS. Then I'll focus on why does CAS exist? How do you go to CAS? The roots, the procedure there still under CAS. Then the practical guidance on a few principles when matters are taken to CAS. What is the actual procedure? I'll be, like I've said, I will try to be very brief. You'll excuse me and bear with me. I got an emergency to attend matter at around 11:30. So I may not strictly follow the slides. I'll just go through them, but the good thing they are detailed. I'll leave them behind through ULS. Now, by way of introduction, with the general rule, the growing body of law that governs sports breaks it down, ranging from regional bodies, from your federation, then you go to confederation, that is if it's in Africa, CAF, Europe, you have UEFA, etc., etc. So just like any other governing body, there should be a mechanism that requires resolving of disputes and the rules have to be established. Those rules must dictate the nature of that sport or that practice. If it is tax, probably they will say every principle, or rather every dispute that is going to be resolved must be resolved in the spirit of taxation principles. So the same is analogous to sports disputes. So CAS bases its nature or its statutes or its regulations on international federations, continental body federations, other organizations, which create a channel through which disputes are determined both internally and externally. Internally, it's within your regional body, it's within your sports association or sports federation. For example, here in Uganda, you have FUFA. So you will have mechanisms within FUFA through which sports associations can resolve their disputes. Then after that, probably if FUFA, by subscribing to international instruments, there is an agreement between FUFA and FIFA that should there be a dispute, do not go to ordinary courts. Can we resolve our disputes within our means? So a dispute may probably be taken to FIFA where you're not happy within the FIFA dispute and judicial mechanism chambers. Then by way of an agreement, as we shall see later, then you submit to the jurisdiction of what I would call the external adjudication chamber, which is CAS. It is external because it is not an extension of your federation body, your sports association, name it. So the nature of this is that it offers various forms of ADR in the sport, and it creates the uniqueness of CAS. So CAS, just like any other sports, any other arbitral institution. I'll give an example of the London. I've been reminded. Try to scroll to Philip. Thank you. So I was saying that CAS is a private arbitral institution, just like the London Court of International Arbitration, LCIA, and the International Court of Arbitration of the International Chamber of Commerce, ICC. So the nature of CAS is like, or is analogous to those two I've mentioned above. So what now makes CAS different from other bodies or adjudicative bodies? I'll start by probably hinting on the nature of sports disputes. The nature of sports disputes. Whenever there is a sports dispute, parties involved in sports disputes always have three possible ways of resolving them. That is, as we shall see later, they can run or appeal to the internal authorities of their sports federations. That is both national and international. So that the first nature is you run to your dispute resolution mechanism chamber within your sports federation. If it is rugby, you go there. If it's a swimming federation or a federation for Ugandan swimmers, you run there. If it's athletics, world athletics, you do that. So just like we all know about the rule of exhaustion of internal remedies, local remedies, you don't rush to CAS, of course, in exceptional circumstances, as we shall see, without first exhausting the internal mechanism or remedies. The other is that they can take their disputes to the ordinary competent courts. This one, the nature of the dispute, probably if you do not have a clause in your arrangement that you should submit to CAS. But like we shall see, international federations will punish you because the nature of sports, it is a specialty sport. It is a jealousy. Sports is a jealousy mistress. It does not allow you to mix it with other people. So it demands that all sports wrangles, in other words, do not expose your dirty linen. That's why it is against taking the sports disputes to ordinary courts. But actually, you may take them, though there are repercussions, especially where the international federation, subject to other international instruments where you subscribe. In this case, I'll use Uganda. The other is you may submit disputes to private arbitration or mediation. So as practitioners here, it is important to point out that the regulations of sports federations cannot in one way exclude an appeal of a dissatisfied member of a sports federation to run to external judicial discretions, as I'll highlight briefly later. I'll give an example of the Caster Semenya case, the Muntu case. What people will ask probably that if a dispute has been resolved by CAS, can I appeal against that? I'll highlight on that later on. So rules have been developed to determine, you can go to the next slide, to determine the nature of the proceedings that are supposed to be entertained before CAS. So by its nature, the CAS is dedicated to hearing and settling any disputes directly or indirectly relating to sports. Like you can see there, it's pure about mediation. Mediation is another angle, but there are things you cannot mediate upon, like anti-doping disciplinary cases. Whereas CAS encourages mediation, there are some unique cases whereby it will assume jurisdiction and it will deal as a disciplinary chamber. So those cannot be mediated upon. That is those cases that arise as a result of breaching the anti-doping code. The same CAS can handle sporting and commercial disputes, but they do not handle on-field play disputes. Issues to do with red cards, you've exchanged with the opponent, you did something that is contrary to either IFAB rules. They don't. On play or on-field play cases, they don't entertain them. But as we shall see later, there is a slight exception to which some on-field play cases may actually be converted into. Probably my senior Dev will guide on that. So the other is you shouldn't be an employee of that body to bring or to, of course, the aspect of conflict of interest. You may scroll down. I'm trying to go through them very fast because of down there indicate its history. At the beginning of in the 1980s, there was an increasing number of international sports disputes, and there was also lack of an independent body to deal with those disputes in a flexible, quick, inexpensive, and what you may say, in a binding manner. So because of that, this prompted a number of international sports federations to look at the situation and see what could be done. So later, there's a gentleman called Keba Mbaye, who was from Senegal, and he was a member of the International Olympic Committee. The gentleman, at that time, he was a judge at the International Court of Justice in The Hague. And he was asked to chair a working committee or party with the aim of preparing a few statutes of a sports dispute resolution body that would operate during that time, which would become to be known as the Court of Arbitration for Sports. My former teacher, Dave, has already indicated that at times we call it CAS. Then I think in the French jurisdiction, it is called CAS. So in 1983, the International Olympic Committee officially ratified those statutes which had been prepared, the statutes of CAS, which came into force on 30th June 1984. On the same date, the CAS became operational under the late Judge Mbaye as its president, a position he occupied with distinction until his death in 2007. So CAS is a brainchild of the International Olympic Committee. Members had to brainstorm and they came up with a unique body that would be dedicated in hearing and settling any disputes that are directly or indirectly related to sports. The other thing I should talk about, it is located, or station,
Ryan, we are losing you.
kindly confirm, can you hear me?
Yes, we can hear you now.
Okay, so because CAS is based in Switzerland with its seat in Lausanne, the CAS is generally governed by the Swiss law. So the Swiss law is usually the applicable law for those, and also the CAS court office headed by the Secretary General is in Switzerland, even when it hears cases that are outside Switzerland. However, it also organizes ad hoc divisions that deal with other administrative issues. For example, during the Olympic Games, the CAS operates an ad hoc division, which was first set up in 1995. So it sits to resolve disputes relating to the games within 24 hours and free of charge. So those ad hoc committees, also all athletes participating in the summer and winter Olympic Games, have to submit their disputes to the CAS ad hoc division. They are quite many. The other thing I should tell you about CAS is that, like David indicated, you have to submit to the jurisdiction of CAS by way of an agreement. So your agreement, just like we all know, arbitration clauses, every contract or your agreement as a federation with any other international body, you must agree, there must be a clause that indicates that in case of any dispute, we shall go to Court of Arbitration for Sports. Of course, many have argued that this owes the inherent jurisdiction of a domestic court. Case law has actually highlighted on that, where parties have agreed to first resolve their disputes through arbitration. That does not owe the inherent jurisdiction of the domestic court, in particular here in Uganda, High Court. The decisions of the CAS shall be binding and final. Of course, like to preempt any other's question, there are instances where after you've received an award from CAS, some people run to the European Court of Human Rights, others run to the Supreme Court of Switzerland, as we shall see later. So CAS is composed of purely arbitrators. It has a minimum number of 150 arbitrators. Of course, there are more who are specialists in arbitration and sports law. Those arbitrators, like Dev is appointed for a 4-year renewable term and must sign a letter of independence confirming that he will act in a fair manner and impartial. So those CAS arbitrators sit on panels composed of 1 or 3 members, and they're not generally obliged to follow earlier decisions. So CAS is not bound by the doctrine of stare decisis or precedents, but they usually do so in the interest of legal certainty. So they do follow, but it's not a general rule, but they should follow the doctrine of precedents or stare decisis. This is because each case is determined based on its peculiar facts or circumstances. The procedure, in brief or in summary, we have what we call ordinary arbitration proceedings. How does it work? You see, like I've told you, CAS is not a conventional court in the sense where parties appear and go for a formal trial. No. It's not a conventional court. It's purely arbitration. Parties submit to the arbitration. They agree to be bound by the award of an arbitrator, and for a dispute to be heard by CAS, it needs to be a sports-related dispute. You don't take these other non-sports-related disputes. Then that agreement must be in writing that we shall submit to CAS. This happens either after the dispute has arisen, or more often than not, it is done before the dispute has arisen. For example, under ordinary arbitration, the procedure to be followed is that you can run to CAS by way of first instance. There, you do not go by way of an appeal. You go there by way of first instance, and later the other approach is you can go there by way of appeal. Now, by way of appeal, you've gone to FUFA, FUFA has disciplined you, then probably you try to run. Let me just give an example here. We had the president of FUFA had an issue with FIFA where he was suspended over allegations of some tickets to do with World Cup. So in such a scenario, if you appeal within the internal dispute mechanism of FIFA, then you can, after a decision has been issued, you can run to CAS. You cannot jump if you are a sports person, coach, footballer, sports organization. You do not jump with the internal mechanism of FUFA to run and go to CAS. So the second approach is running to CAS by way of appeal. The other is the time within which appeals are handled. Let me wind up with this. Philip, if we can scroll down to appeals.
Brian, there you are.
Yes. So, like the ordinary procedure I talked about, there's no time limit within which to file your claim. For as long as a dispute between the sports personality, Philip and Brian, you have your contract, you can run it straight to CAS. Then appeal, you either appeal within 21 days, that is the rule in the CAS code, or where it is indicated in your regional bodies. For example, FIFA, the regulations that establish football governing bodies, they provide for particular days. For FIFA, Article 67 of the FIFA statutes, they say 21 days after decision of FIFA has been given. That's when you run to CAS. UEFA, Article 62.3 says 10 days after decision has been given. So the appeal can be, in the absence of that, then we shall follow the ones that are indicated in the CAS code. When you file your appeal out of time, there's no extension. No extension does not apply. However, if you've submitted your form and it is lacking in substance, then the committee or the CAS panel may, after probably the time has expired, they can grant you a period of 10 days and you correct your application or your form. I think I'll just, okay. Thank you so much. I'll just share the detailed presentation for the rest of the members to go through. Probably Dev may help me highlight, since it's still here. Kind of allow me excuse myself for another assignment or another engagement at 11. Thank you so much.
Thank you, Brian. I hope Dennis is still online. Dennis wanted to share some experience on the agent rules for the benefit of our Ugandan lawyers. If he's online, he can come in. Before Dave.
I'm online.
All right, thanks.
Thank you, Brian. Of course, for purposes of consistency, it should be better that I talk about, since Brian has been generous enough to avail us some good minutes for our education. What I want to talk about before I go into the agent issues, before Dave comes in, because being an arbitrator, I wanted to first share the experience. For example, FUFA has been appeared before CAS 2 times. Unfortunately, one of the cases was aborted because of the costs. And it was through an appeal by the football club. And we learned a lot from that time. But the critical thing for the benefit of our lawyers here, as far as CAS is concerned, we all know it's an arbitration, it's free will. You either choose to go before CAS in form of arbitration or not. So when you're advising your client, I think that would be the first, if we are in a Ugandan case. At the time of executing an agreement, you advise your client whether we shall have arbitration as one of the modes of a dispute resolution. Unfortunately, in sport, especially in football that I've worked with for some time, you may not be at great liberty to choose whether you choose CAS as one of the modes of dispute resolution. No matter what happens, it's dictated in football from FIFA. It comes to member associations like FUFA, and we also put it down to our members. No matter what happens, in simple terms, FIFA will ask Uganda that if you want to be our member, there are qualifications that you have to fulfill in your constitution. And one of them, you must indicate a clause that CAS shall be one of the bodies that will provide dispute resolution. In case of any dispute and you have completed the appellate decision in FIFA. When it comes to Uganda, we also ask our members, these are clubs, these are players, and we ask them, dear clubs, if you want to be part or to associate with us as FUFA in association football, we need a clause in your constitution, which clearly states that in case you have exhausted the dispute resolution in FUFA, that's being the appeals committee of FUFA, the direction is we submit our claim to CAS, not to ordinary courts of law. So that's very critical for our lawyers who are in here to appreciate that whenever you see a dispute between a federation and a club, which always represent, or a player, you need to identify whether that truth is there. But as I mentioned, it's always mandatory in simple terms for football and the member associations to appear to take their disputes to CAS. One of the hidden facts that I wanted to share with our members, one of the cases was aborted because of the financial costs. A club was asked 40,000 because it had requested for 3 arbitrators. And sometimes that cost, you may not see it in the regulations. They only share it when you have at least done the preliminary stages of filing. So FUFA, we are supposed to pay, for example, by way of example, 10,000 or 15,000 US dollars, and then the club. And that is a huge cost on some of our clubs. And sometimes there are gimmicks where one of the parties, especially the respondent in case of appeal, refuses to pay. You may find the other party has to pay such that the case can now be fully registered and the arbitrators are appointed. So those are the best things that you need to understand. And one of the things that you need to take away as lawyers, if the dispute really is not so substantial, you go for one arbitrator. It's not very expensive. You go for one arbitrator, it helps to reduce the cost. So CAS is very efficient. The time we appeared, we relied basically on written submissions. You don't have to travel to Zurich in cases, special appeal cases. So it's not something that we need to fear. It's very efficient. The rules are very simple. It's only the cost that normally has an issue. Those are now different from cases like drugs, doping cases. I've not handled any of that. But lawyers should also encourage that we'll go before CAS. For the time with the cases we read, it's very efficient. It's not something to intimidate. I've represented a club via written submissions, and we are successful. We had a club in West Africa which had refused to pay transfer fees, and CAS helped the club to recover, a local club, at a very minimal cost for using one arbitrator. So that's what I wanted to share as of experience from our Ugandan setting as we appeared before CAS, and I know very many lawyers are willing to represent. And one thing I want to assure you that whatever we do, me as the head of legal at FUFA, we always don't even think about the Ugandan courts. We think about CAS. Did we give a party a fair hearing? Did we apply the rules? What the rules say, such that CAS can be able to interpret the process and the merits of the decision. So Philip, I thought that for being consistent, I can stop there. Dave can come in, then we'll come back on the issue of agent to share what's going on in FUFA, such that benefits our Ugandan lawyers and as far as members of this cluster. Thank you so much.
Thank you, Dennis. I'm always grateful for your contribution. Dennis is the head legal FUFA. He has given me opportunity to appear in several workshops with FUFA. He's a very helpful member of the society. Those who have more interest in sports law can always reach out to him. Dave has a second topic, and he seems to be preparing for a flight in a few minutes. I'll give him a chance to come on call. I hope Dave is still there.
I'm here, Philip, and yeah, first of all, I do apologize that I'm gonna have to depart just now. So I've already sent you the first presentation to cascade amongst your constituents. With regards to the second topic, it may be, if it's of interest to anybody, it may be that we can set up another call at another time, and I'm happy to spend time going through that and any other questions that anyone else has got.
Dave, kindly highlight the outline of the second topic, because it's a really interesting one.
Sure.
Yes,
so you had in your kind invitation to me to appear today, you had asked me to discuss a couple of emerging areas in sports practice, and the two that I've decided to cover for you, because we've seen quite a lot of it recently in our work over the last, let's say, 12-18 months, are reputation risk management. Forgive me, that's my alarm saying that I've got to leave for the airport. Reputation risk management, and that ties into crisis management, and also safeguarding, which is particularly important at institutional level, and I'm sure our good friend Dennis from FUFA would also have some views on that too. So if this is something that you guys would like to discuss in more detail at a later point, I'm absolutely happy to go through that with you. What I can do just over the next minute or two is I can latch on to a couple of things that Brian Kajubi mentioned and also Dennis Lukambi mentioned. First of all, just for sake of clarity, I'm not an arbitrator. I'm a litigator at CAS. I appear at CAS frequently. I litigate before arbitrators, and with respect to all of my friends who are arbitrators, I prefer the litigation side of it. I don't think it's my time at the moment to become an adjudicator. I prefer making oral submissions and written submissions on behalf of clients. But through that, we've operated at CAS frequently, and Dennis is absolutely bang on. The economic reality of participants in many different countries, as he's also touched upon for Uganda, often makes CAS appear to be cost prohibitive. And in some instances it is, and there are some tricks out there, like Dennis mentioned, where ultimately the burden of cost falls on the claimant. If a respondent, so let's say after a certain period of time, when the case has begun, the CAS would then determine how much advance of costs would be required. So Dennis mentioned in his case, it was 40,000 Swiss francs it would be. That would usually be divided equally between the parties. So if you've got two parties, then each of the two parties would have to pay 20,000 Swiss francs each for the case to proceed. Dennis also very correctly put forward that there is no there's no metric, there's no tabular system for one to be able to determine or ascertain how much their case is going to cost. It's only over time now with, for example, our experience at CAS, where we've probably been involved in, dozens of cases, let's say, just to keep it easy, if not hundreds. We've kind of got a gauge of what kind of case will equate to what kind of amount, and therefore it enables us to give our clients a bit of support or a bit of guidance. But in reality, there's no way for us to be able to determine, for anyone to be able to determine how much a case will cost. But let's say, for example, it's 40,000 Swiss francs, two parties, each party has got to pay 20,000 Swiss francs. The claimant pays his or her 20,000. If the respondent doesn't pay, then the case will be frustrated until and unless the claimant can pay on behalf of the respondent or find a sponsor to pay on behalf of the respondent. If they can't do this within time, then the case is closed completely. So there are some tricks like that, so to speak, which probably imbalance the situation somewhat. But aside from that, as Dennis rightly pointed out, it's an institution that should not be as intimidating as it probably is to many. It does work well, it is efficient, it's as quick as it possibly can be, and there are some mechanisms to reduce costs. First of all, not requesting a panel of 3 arbitrators, having a sole arbitrator that effectively cuts your costs into 3, into a third of what it might have been. Also, having a decision based on written deliberations alone, as opposed to oral argument. So as Dennis mentioned, you don't then have to fly over to Lausanne, even though now the oral hearings are generally being held via Zoom or WebEx. You don't have to take the time of an arbitrator or the time of all of the lawyers in handling this kind of matter. Having a decision simply based on the written submissions save costs. So there are ways in which this can be more accessible to a wider market, particularly in South America, in Asia, in Oceania, Eastern Europe and in Africa. And again, for those of you that focus on areas outside of sports and work within the national courts, it's important to realize that sport is this incubated thing with its own governance, its own legal mechanisms, both nationally and internationally, and often across most countries around the world, its own special exemptions or recognitions for sporting activity, which is why sport is separated from the rest of life. And furthermore, we've got to consider that when we talk about sport and a dispute arising, Dennis is in the market. He said it himself. The first thing we're thinking about is not the state courts in Uganda or the state courts in Ireland or wherever it might be. We're talking about CAS. That's what we're referring to. We're referring to a private body that works under the guise of Swiss law. So it's just imperative that all of you who leave this session today, from a CAS perspective, realize these things, if I may put them forward. So Philip, again, forgive me that I've got to depart early. I've already sent you the first presentation, and I am completely at your disposal if you and your constituents want to have another session on rep management and crisis management at another date. But I'll have to depart, and thank you again for your invitation.
Thank you, Dave. I'm always happy that you always answer any call that comes to you. I trust that the members have benefited. I've seen quite a number of comments. So someone says it's an area that he had never thought of having interest in, yet he's shocked that people are already practicing sports law. I think I'll let you leave, because surely over the last month you've been telling me that you have a flight, so you have to catch the flight on time. I don't want to keep you here for long.
Thanks, Philip. Hopefully I'm going to see the Ugandan boxing representatives in Abu Dhabi. So I'll definitely be in touch with you about that in any case. But
Sure,
all the best, and
Sure,
wishing everyone on the call a good day.
Thank you, Dave. At this moment, let me recognize a few of our members before we get into our next panelist. The ladies who are first on call: Caroline Namara, Nakuya Sharita, Gertrude Nakamanya. He's on call from Sinopec International Petroleum Services Company Limited. I see a lot of ladies. Flavia Asimwe, thank you. Kunihira Winifred, thank you. Thank you. Ernest Lutaya, thank you. Waswa Fahad, and so many others. Councillor Joseph Buembo was on call in the very first hour. Thank you for being on call. We have a few questions that have been raised. And this question, I think, will go to Dennis Lukambi, who is assisting me on the other side. Muhumza Japheth Albert, who was also early on call, has a question. What should happen where a member organization of an association skips the internal mechanisms and goes straight to the courts of law, especially where the courts of law decline to uphold an objection based on the association clause that all disputes must first be referred to the internal procedures? I'll invite Dennis to address this issue, because as members of federations, we've always had a problem. We've faced the same situation in boxing, where our constitution and the Olympic Committee Charter refers us to CAS, and members with issues have gone straight to courts of law. So I think the same has happened in FUFA. Dennis, if you're on call, please help me shed more light on this.
Okay. Thank you, Philip. For the benefit of the member who asked, what happens is that indeed, so many members always refer to go to courts of law, because we live in a society where even lawyers and litigants and members, it's hard to concede. It's very, very hard to concede, especially in our society. you sometimes reach cases which can easily be determined by the panel of internal disputes, but realize members will never accept because of several reasons, ego and other areas. But what happens normally, first of all, we have to appreciate that we always go to those members, the courts of law, and defend the institutions, either between FUFA and the club or boxing and other members. We don't keep quiet. We go to courts of law and inform court that we have a binding clause referring this matter to arbitration, either to international federation or to other private international arbitration centers. Some judges always not appreciated to the dot, which with due respect to them, but we have judges, especially in the commercial civil division, we have over now 4 cases that His Lordship just second and dismissed and refer the parties to go and complete the arbitration process. So we first defend the institutions in courts of law, and then in our regulations in football, we always question the parties before they join to be members. We inform them that, dear club, if you want to be part of association football, once you attempt to go to courts of law in a dispute of a sports nature, you will be sanctioned. Either you'll be expelled from the association, or you will pay fine, or you will be sanctioned in whatever it is the sanction that are stated in the constitution. So normally that's what happens. And for us, clubs have always gone there. We don't always push them to that disgruntlement. Sometimes we know the advocates. Unfortunately, all the cases have been lost because of that clause of referring to exhaust the internal mechanism. We've not lost any case as an institution. And you find that clubs and players have paid some heavy costs in that, and they also suffer other sanctions. We deduct points, we demote them. So depending on the gravity, and each case is determined dependent on its own factors. But you should understand what we call sports nature or matters of a sports nature and commercial matters. For example, if a player takes us to court as an institution or a club for image rights, that's not a sports matter. That matter, the player has a right to go and defend his personal rights in courts of law. Contractual disputes, for example, between a player and a club, the player has a choice. He can go to courts of law, or he can come and use the internal dispute systems. The maximum our dispute system can take is around 4 to 6 months, the maximum, but some have been resolved in 1 week. That may not happen easily in courts of law. And by the time you finish the transaction in courts of law after 2 years, the contract expired, and you can't allow a player to come and play with another club until that is resolved. So in discussing this in our nature as a country in Uganda, that's what basically happens. And I would advise, especially our land friends who are here, always discourage, unless it is inevitable, but always discourage your clients to refer matters of sports nature, promotion, relegation, club licensing, failure to fulfill the requirements. Once you run to the courts of law, the precedents will have now all the cases have been lost, and the precedents are already available on URI and other areas. So it's highly discourageable. And then I help your client not to suffer other functions. For example, recently we had a case of Chetume. If those who are following it, that case, that club was supposed to play in the first division. The lawyers went to court. Of course, the matter was settled, but still you realize the club was not able to remain in the first division. It had to go to second division. And there are so many challenges to that effect. Despite that the matter did not conclude, it was settled, but the sanction remained. But when we are settling, we tell you, we inform you, either boxing or football or other federation, that we cannot at any time compromise on the regulations. You can withdraw for cost purposes, but you still go down. You can't be in the first division. So on that question, that's what I can share for now, Philip. But you had said that either after the next presenter, we shall talk about the emerging areas in sports law, which they were supposed to cover in that time, especially in Uganda, because you realize so many things are coming up, and we need to interest our fellow lawyers to see that we tap into this industry together. Only us who are working with federations cannot consume this business. It's beyond us. And I would love anytime you give us opportunity to share with them in that perspective. Over to you, Philip.
Indeed, thank you so much. Thank you so much, Dennis. Dennis, like I said earlier, is always open to assisting any person who is interested in practicing sports law. He has worked with FUFA, I think, almost all his entire practice. In the same spirit, Dennis, I had a very interesting question from Haruna Mbeta. It's a Hello Kindly guide on the law governing the establishment of football playgrounds. There's quite a number of artificial turf playgrounds that are cropping up. I also had the same question some time back. Someone wanted to see whether he can sue certain people for making too much noise as they play football late in the night. Is there a law governing the establishment of football playgrounds? Because this is in your field especially.
Okay. That's interesting. And even as at FUFA, we've received those complaints. But what I want us, because now this is the cream of sports law that we are trying to develop the industry together, we need to appreciate what we refer to as private rights and association rights. When we talk about football and other sports, this, for example, boxing, athletics, there's what we call the association and then the private nature. For me, if I wake up and go to the gym and train and start practicing boxing with my colleagues in the village, that may not be under the governance of Uganda Boxing Federation. Until I register with them, comply with their rules, that's when I can be part. But you cannot go and represent a country unless you are sanctioned or gone through the systems of Uganda Boxing Federation. So the reason why I'm highlighting that background is that in football, we only regulate the clubs that are our members. And our members, the Villas, the Vipers of this world, the right to associate with us helps you to go and compete on the continent. Your players go and compete on the continent. Your players can be transferred to Europe and earn a living, which may not be happening on private individuals who are not part of the association. In terms of stadium, our rules don't allow clubs to play beyond 10 in the night or beyond midnight. There are times, I may not have them offered, but there are times when we don't allow them. The rules do not allow clubs to play beyond a certain time. Now, those cropping stadiums, those are private businesses. No one should lie to you that FUFA, you have a right, unless we find our members playing in those stadiums, but they are private. And I think as a practitioner, the best route would be now, normally I've seen some lawyers litigating it under nuisance. It has its basic tenets. So FUFA, you may not have a route to guide or protect the rights of the members surrounding those stadiums, because those are private businesses which you don't have control over. So courts of law can come in, except when you hear that there is a game, for example, at St. Mary's and Vipers, we can write to them, and then we can at least have a rule about it. But these private stadiums, the time I've worked with the federation, those are private businesses, which I think now the courts of law has the jurisdiction to handle them. I think I've answered better very well. I may not be that perfect, but normally it's under nuisance that we can recover or have a solution for the clients surrounding those stadiums. Over to you, Philip.
Thank you, Dennis. I think the question has been answered right. I want to thank Bajeju Ivan for the good comment. It says, good morning, members. Sports law is an interesting area. In the same spirit, Mutumba Collins is happy to hear that he's hearing from the best brains in the sports practice. And Nicholas Cheswa is also happy that it's quite uninteresting and it's a field that not many of us lawyers have traversed. Yes, not so many lawyers have had a chance to engage in this field, but it's quite interesting. So many people will ask you, why are you into sports? It's not paying off, but it has very unique aspects. If you interest yourself, I have personally gone ahead. I've done a course in sports arbitration at CIAB Kenya. It's quite interesting. And it's FUFA President Magogo has said sports is a multi-billion industry. We cannot limit ourselves. We cannot. Dennis Lukambi is very useful, like I have kept mentioning. He works with FUFA. He's always open to helping anyone in anything that regards sports and the law. At the moment, I think Ivan is preparing for a very hot topic that is even ongoing on the floor of Parliament. Ivan, can I please confirm that you're on?
Philip, I am on.
All right. Ivan, today's New Vision, page 12, has this public notice, the National Sports Bill. I trust that is the Magogo bill. That is why I wanted Lukambi to be live and you, as we go through.
Are you trying to say Lukambi is the drafter?
I don't know, but it has been dubbed the Magogo bill. The Magogo bill was read for the first time on Wednesday, 9th November 2022, and they're inviting interested sports stakeholders to contribute to the discussion. I also know that the National Physical and Education Sports Policy and National Physical Activity and Sports Bill is also in Parliament. However, like we have always argued off record, I personally subscribe to the old law. Dr. Don is engaged. He had promised me to be on call, so we can have a very heated argument, but I'll let you have a discussion as per our topic on the bills vis-a-vis the old law. There's a question from Max Sinabulia, which can act as a pointer. The question is, what is the major cause of the delay in passing the new proposed regulations, and what are the main? No, this is, I think it's a second question, which regards the act, but you're going to be discussing the same. I'll let the floor open for you. Ivan needs no introduction, that's law.
Thank you very much. I'm flattered. Mr. Moderator, a couple of people are saying they cannot access the link. I don't know whatever is happening with that, but just let me get into it. Thank you very much, Moderator, and thank you very much for the invitation. I am honored to be speaking to the membership of the Uganda Law Society on this very pertinent topic, and I'm also honored to be following up the very gigantic footsteps of my seniors, Mr. Dev Kumar and Mr. Brian Kajubi. Brian Kajubi is the one who inspired me to speak. I saw the man introducing sports law at UCU, and I told him, sports law? Yeah, I was like, let me start reading. And before you know it, I was getting serious about it. So Brian Kajubi is a big mentor of mine. So yes, this Ivan, is a very, yes.
Just a second. Let me tell you something funny. Yes. I think it was a petition on ICAMEC.
Yes.
We had an argument before the session with Brian,
yes.
And I told Brian, you know what? If the seniors are taking this route, there are so many opportunities that we can open into. And one of them is sports law. Surprisingly, he never slept. The next I heard from him, he was a lecturer in sports law.
He actually set up a subject at UCU. That's what I know for a fact. I think even his own invited Dr. Don to help with the teaching. Anyway, let's get into it. So I have a small presentation. Let me share my screen. I don't know if, let me see, share screen. Forgive me for its lack of finesse and for its being rough. I've since learned that PowerPoints must have a certain beautiful outlay to them, but I'll improve it and perhaps send through a final version of it to the Secretariat. So this is a very pertinent topic to Uganda right now. And from a sports law angle, or even a sports scholarly angle, I'll look at it also as a very controversial topic as far as sports law is concerned, or even the law in Uganda is concerned. The topic I've been given is by Mr. Mudabi, was assessment of Uganda sports law, the new sports bills vis-a-vis or versus the National Sports Act of 1964. My name is Ivan Ojakol. I'm a partner at Matrix Advocates, and I lecture the law at International University of East Africa. First of all, as a preamble, it is even controversial for us to be talking about a law governing sport because of the origins of so-called sports law, lex sportiva, as they call it in those circles, a sort of parallel legal system that exists parallel to national or national laws or even domestic laws that sort of claims a certain level of independence away from national laws and governance of state institutions. So that is a bit controversial. And if you look at it, I want to ponder about it later on. And especially Mr. Lokambi, who's at the Federation, might want to think about this very, very critically, because this creates a certain level of controversy as far as I'm concerned. But nonetheless, again, as a government, you cannot blame the government or even the powers that be for wanting to regulate the sector. Sector is big. Sector has billions and billions of dollars being injected into it. The sector has a lot of potential to take the country forward. As you know, sports and the social cultural ethos of a country are more or less intertwined. Sports many times defines, as you've seen in FIFA Uncovered, even defines the politics of a state. Countries want to be associated with a World Cup for what they call World Cup. Is it called football washing or World Cup washing now? You know, if a country has a bad record internationally, they won't be associated with World Cup, so that creates a different image of them. So it is a big thing, and you cannot blame a state or a country for wanting to regulate it or even govern it. So, and increasingly what's happening in the world is that there's now a hybrid approach. Countries just do not want to sit back and let these federations say that we're independent and we are governed by, we're only governed by the law of FIFA or the law of FIBA, etc. and etc. So countries have put their foot forward and are saying, no, we should find a way of regulating this sector. Of course, the complaints that come through every day, as you've heard, you know, there's a problem ongoing right now, allegations against National Council of Sport, etc. and etc. So this law called the National Council of Sports Act is more or less, as far as I'm concerned, was a very shallow law, because again, you cannot blame the drafters then or the people that came up with it in 1964. Sports then was not that big. It was honestly just a leisure activity. And if you look at the wording of it, it just created this National Council of Sports as the body, government body to regulate the sector or to govern the sector, but to govern majorly, or actually to govern only and only amateur sport, because perhaps the people then were not seeing the commercial side of sport, and it had not grown that big. And now, if you've also watched FIFA Uncovered, for example, you know that until Sepp Blatter joined FIFA in the early 70s, and until 1974 or thereabouts is when FIFA started getting into partnerships with the Coca-Colas of this world and even got a proper big office in their headquarters in Switzerland. So sports then was not at this level, and you cannot blame the drafters then. So it simply established NCS and gave NCS the mandate to govern amateur sports among other small powers here and there. And importantly, of course, NCS got money from government and was supposed to account in line with those who get money from government, how they are supposed to account. That is through the Auditor General, etc. and etc. So that, in a nutshell, is that act. There's really nothing much. Of course, around after a lot of fighting that was going on in the sector, Jessica Lupo managed to push for some regulations in the early 2010s. And those regulations are called the National Council of Sports Regulations of 2014. Importantly, those regulations, as you can see, the case which I've quoted there, Proline versus Lawrence Mulindwa, FUFA and others, and I think maybe, I don't know if Dennis was involved in it at the time, but if you look at the judgment, you can see it was a common PO raised by FUFA lawyers always whenever matters were put against them, that, hey, you're suing a non-existent entity. You have no local standard to bring this suit against us because they were non-existent, sorry, they're not registered legally, and they claim to be independent. So, we used to have suits like those, and many matters that disposed of the PO. But of course, in this case, it was a judicial review matter, and Justice Bamwine allowed it to proceed, because under judicial review, you can even get a remedy against non-existent entities. So it was a common PO. And to address that, to remedy that, those regulations came into force in 2014 and required that every federation, national sports association, be incorporated, registered, or have some sort of legal personality. And that is when now you can see when you're suing FUFA, you sue the trustees of FUFA, etc. and etc. So a couple of them are registered as trusts, I think most of them, but the others are still registered as under the NGO Act, etc. and etc. So that is as far as the NCS is concerned, which NCS is going to be repealed. Sorry, the National Council of Sports Act is going to be repealed by the incoming either Magogo bill or the Physical Activity and Sports law, as I'm going to go into. So enter Magogo, Honorable Honorable MP and President of FUFA. He came up with a bill. We must credit him as a stakeholder in the industry. He thought about this gap that was there and the need for the regulation of a sport. And he came up with this law. I don't know if Dennis helped him draft it, but the law is there. It's called the Magogo Bill, the National Sports Bill 2021, famously called the Magogo Bill. In going through the Magogo Bill, I'm going to be guided by the objects of the bill, which we shall keep on interrogating later on as we go through the salient aspects of it, whether indeed those aspects have met what Magogo envisaged through the objects of the bill. He wants to streamline the management, promotion, and development of sport in Uganda from amateur to professional. He wants to prohibit vices in sport, like illegal manipulation of sport, match fixing, corruption, promote a drug-free environment, that is doping, fight against doping, for example, harmonize and ensure uniformity in the registration and incorporation of sports organizations in Uganda, codify the obligations of Uganda as a state under international sports law. So those three should be our guiding points as far as interrogating whether Magogo's law, as it is right now, before, because I think Uganda Law Society is appearing on Monday, and a couple of other stakeholders will appear thereafter. I think even others are appearing today and maybe tomorrow to give their views, because the bill is now at the second reading. Another controversy, by the way, because when Anita Among pushed that bill to the second reading, the Honorable Speaker of Parliament, Right Honorable Speaker of Parliament, Minister Ogwang rose up and said that him and Magogo had met very many times and had harmonized the law. So it was quite funny that apparently Mr. Magogo had gone behind his back and pushed for the bill to be, for his bill to be pushed. So it says the National Activity and Sports Bill is actually the right law, and that is going to be a very interesting contest. But the speaker seems to have guided on that and said that the two can be harmonized. Because I think, for example, the Succession Amendment Act had two bills also, a private member and government bill, and I think even the Mining Act had two. So they were harmonized at the second reading. So hopefully we can have a proper harmonization. Of course, after thorough consultation, as I shall recommend later. So streamlining management of sports, harmonization, and ensure uniformity. Like I mentioned, some are registered as trusts, others are registered as under the NGO Act as companies limited by guarantee, others as companies, others are not registered. On the floor of Parliament the other day, Ogwang was talking about during this NCS probe that there are briefcase sports federations that are running right now. So that news needs to be harmonized and ensure codification with international sports law. As you've seen, we have been talking about the Court of Arbitration for Sport earlier, and let us interrogate this law and see if indeed it qualifies and meets international obligations under international sports law. So it retains the National Council of Sport as the overseer and regulator of sports in Uganda. That body that many, and I know Philip being involved in the federation, I know has very many problems, I'm sure, with it. We shall not go into that. Controversial as it is, it has been retained here. And it has the same powers as both a regulator, as sort of the government commercial arm of sport, the government implementer of sport. It is the one responsible for running grassroots sports, ensuring that facilities are properly run and everything, and literally has responsibility for all sports infrastructure in the country. The likes of maybe Lugogo, the cricket oval. There's a very interesting debate about Nambole, which maybe I'll go into later on in my slide. The minister the other day seemed to, when Dr. Oguel was talking about Nambole as being one of the facilities they run, he seemed to shut him up and sort of divert from what I was saying and say that Nambole is not within the ambit of NCS, which was quite controversial, I thought. As opposed to Nachivubo War Memorial Stadium, which is currently being renovated by Mr. Hamchigundu, and that has a particular act, I think it's called the Nachivubo War Memorial Act, something like that, that properly governs how it's run and everything. Nambole does not have that. So Nambole ideally should be under NCS, but the minister on the floor of parliament, the Minister Ogwang, told the committee that guess what, this is not under the ambit of NCS, quite controversial. So that was those important functions as both a regulator and the body that literally implements the law on sport as far as mainstream sport is concerned. And as opposed to the NCS Act, it comes out outrightly here and says that it is an independent body with corporate personality. That is not clear in the NCS Act. The NCS Act just says, the old Act of 1964 just says that we are a body corporate that can be sued and sue in our own name. But also importantly, this body also has the power to appoint a tribunal, which is a very controversial concept as far as I'm concerned, and I'll go into that later. As far as I'm concerned, I do not like the fact that this bill has maintained NCS as it is. This bill should have borrowed from the Kenya Sports Act of 2013 and divided the NCS into a number of different bodies. For example, in Kenya, there's Sports Kenya and the Sports Registrar in Kenya. Those are the two bodies. One, Sports Kenya, is the commercial arm. It runs sports, down, whether it's at grassroots level, as far as implementing sport is concerned and implementing the laws. And then you have the registrar, which is like the licensing and regulatory arm of the governance of sport. So I think NCS has too much power, and that power is what has caused some of the problems that are before Parliament right now, and has been more or less abused. That is a major allegation for me, but yes, I believe it has been abused. For example, allegations of NCS, if you're not in their good books, you won't get some money. If you're not in line with what they want, they may not register you as a federation. So things like those are some of the allegations that have come out strong. So divide NCS. That's my first recommendation from the Magogo bill. As far as incorporation and registration is concerned, I'm not sure if Magogo, in line with our earlier object, which is our guiding principle number 2, ensure harmonization and uniformity in the registration and incorporation of these organizations. I'm not sure if the Magogo bill achieves that here, because the Magogo bill creates 3 interesting bodies. It creates what you call a National Sports Association. It creates what you call a National Sports Federation. It creates what you call a National Sports Organization. Very, very interesting 3 bodies. 1, an association, National Sports Association, as per the bill, is a body that is recognized and registered by NCS and regulates an amateur sports discipline. A National Sports Federation is a body that is incorporated. I've added another word now, from recognized and registered. I've added incorporated, recognized and registered, and manages a professional and amateur. So I hope you're getting the difference. The other one is just only recognized and registered and manages an amateur sports discipline. The Magogo bill is saying this one is an extra step. We go one better and say incorporated, recognized and registered, and manages both professional and amateur. Now, National Sports Organization is a term that you can use to refer to any of the 2, and also something called a community club. So in other words, if you're confused about whether a federation or an association is a federation or an association, you can just say it's a National Sports Organization. But in my view, this is a very unnecessary appendage. And as you know, there should not be ambiguity in legislation, because you see, yes, it may look clear to a person who has properly addressed their mind, as a legal mind, for example, but someone out there who's reading the act may get confused. So I think it is very unnecessary, and just leaving National Sports Association and Federation is enough. You don't have to go the extra mile and say organization, but that's the debate that you can have at the end of my presentation. So I think that one should be removed. But again, in line with the harmonization of these registration and incorporation mechanisms, is an interesting wording. Remember, if you go back to the Magogo, the objectives, maybe there's something I missed out, but it also sort of attempts. Remember, at the heart of sports, from a purist sports law perspective, sports was envisaged as an independent industry. In other words, sports has its laws governing it, and you as nations have your constitution and all other laws that follow that. And that is why Mr. Luka and Mr. Brian Kanjuli were earlier saying that you don't have to go to national courts. It's something that sports administrators like using, and I've written about this in my article quite a bit. A very famous term across the board, rugby, football, that you're bringing the sport into disrepute by taking us to national courts. So that was the heart of it all. So Magogo attempts to sort of create, and this power is with NCS now. It is not the normal, because under, for example, the old National Council of Sport Regulations, the incorporation and registration was under the body that is responsible for that in Uganda, under the Companies Act. That is the Uganda Registration Services Bureau. But here, in an attempt to create an independence of NCS and perhaps a sort of independence of sports and its governance in the country, NCS is being vested with those powers to register you, to recognize you, and incorporate you. You don't have to go to URSB. That's a bit controversial, but again, the Magogo bill shoots itself in the foot when it goes ahead and says that when you're a national sports association, you are deemed, the use of the word deemed is even a problem. You're deemed to be a partnership under the Partnership Act. You're saying we are diverting and moving away from national legislation and being independent by doing our things our own way. NCS is now the regulator and can register and incorporate it. But at the same time, you're saying under the Partnership Act, which creates, and you're sort of going back, you want to have your cake and eat it at the same time. You're going back into the national laws, at the same time you're saying, no, we're independent. So why are you going back into the the Partnership Act? If you've decided to be independent. That is a major contradiction that will be the subject of litigation going forward. And I propose that that is removed. And even the use of the word deemed. Why using the word deemed? Maybe Dennis Lukambi will tell us later on what was meant by that. When it comes to the National Federation, Sports Federation, it says the National Sports Federation shall be deemed to be a company limited by guarantee. Again, a bit controversial because deemed, again, the use of the word deemed. What is deemed? Just say shall be. Throw your foot forward aggressively and show the world that we have come and we're independent and we're taking charge of our activities. But again, the irony, again, another controversy, you're again coming under a national law which ideally should derive its existence from the grand norm that is the Constitution. So Arenje, again, bringing yourself under the ambit. Controversy, again, as far as sports is concerned. That is something for us to ponder about. But as far as the drafting is concerned, I propose that those provisions be made succinct and clear. If you're going to say we're independent, say it shall be a partnership. Or just leave it like, I don't know, don't include those words that take us back into the Companies Act or the Partnership Act. That is a major controversy that I believe should be resolved going forward. The Magogo bill brings it into play the age-old governance dilemma. Again, is sports, and I've written extensively about this in a number of articles in my column in the Saturday Monitor on whether who actually should govern sport. Is it public? Is it private? Is it a public activity? Is it for when FIFA says we are the owners of organized sport, we're the owners of the World Cup, which World Cup ideally every child in the village wants to be a part of, and you're saying you should not broadcast even Bibandas, a Chivanda, a makeshift video hall cannot just broadcast the World Cup like that because FIFA attempts to overextend its powers as far as intellectual property is concerned and broadcasting rights, etc. So that is controversial. Now, it says that we can revoke, NCS can revoke or suspend a national sports organization, can revoke its existence or suspend it. And that brings it to the old government interference in sports mantra that is always thrown around by especially FIFA and other international sports federations. So if you're going to, you're governing a sports federation now, which is registered as like a company or as a partnership or whatever, or registered under NCS, and then you're now revoking them. But remember, they also derive sustenance. Actually, originally, they derived their sustenance from the International Federation. So this divergence as far as governance is concerned is a major controversy that we shall need to resolve going forward. Because if inevitably FIFA will come and ban us and ban football activity in Uganda or from us playing in the World Cup or whatever competitions or because of government interference. According to them, even where government seems to have legitimate reasons for banning the federation, they'll say no, government interferes. It's only us they should be accountable to, and it's us who govern over them. As you've seen in Kenya with Nicholas Mwendwa, FKF, the minister CS then under the Uhuru government, Amina Mohammed, was not happy after Kenya got out of failed qualify for African Cup of Nations and decided to go hard on FKF and Nicholas Mwendwa, who are rumored to be doing things not in line with the law, or at least misappropriating money. So FIFA came out strongly and banned them. And despite, even as a result, even the Kenyan ladies team that had qualified for the African Cup of Nations and were really looking good were banned from participating in that competition because of that. So that is a major dilemma that must be resolved in this, and this is the controversy of sports law. This is the controversy of sports law, this so-called independence of it, and yet countries are saying we also want to govern. So that is something that we should ponder about, and maybe we shall have a discussion about later. I am strongly advocating for this. First of all, I mentioned the Nambole issue. Why is Nambole not under NCS? That is something that we should interrogate. Is it the minister just trying to put Dr. Ogwele in his place or what? Because I know Mr. Ogwang looks like he's a very tough man and is not even willing. It was literally embarrassing. Dr. Ogwele the other day before the floor, the Committee of Parliament, and I was like, okay. Usually you find the politics and sports leaders or sports head are usually in tandem, but this time the minister was come out breathing fire. So the likes of Munavi who are in these federations should watch the space. So anyway, so accountability and operation, for me, let us, if we are saying we are governing these bodies, let us also look into their affairs as far as monies and grants that come from international sources is concerned. We cannot have a legislation that is, it's neither here nor there. It's as if cautious a bit. Let us go, if I'm saying to regulate the sector, let us go out and regulate the sector. Let us look into everything. And this came out in, again, that FKF Nicholas Mwendwa matter. Nicholas Mwendwa was saying, but we have accounted to FIFA. Why you look into our affairs? It's money. If it's your money, we have also accounted to you. So you have nothing. No cause of action against us. But guys went ahead and actually got something and proper prosecuted him in court, though it was eventually released, but it was quite an interesting one. So I want accountability for even international money, if we're regulating, if I would say it regulate. The tribunal, I thank Mr. Lukambi and his team and FUFA for putting in place the dispute resolution chamber and whatever judicial bodies they have there. I thank Mr. Munabi and his team for having something there, but it is still a problem. In as much as FUFA tries to some extent to at least have a fair dispute resolution mechanism or body to adjudicate these matters whenever they arise, the other federations do not quite have that. Or if they have that, they're really very, very makeshift. Or even some of them are not even composed of lawyers at all. It's quite interesting. So to have unification and harmonization in line with international sports principles, which Mr. Magogo attempts to ensure that our sports law complies with, let us have a sports tribunal, an overall overseeing sports tribunal. Of course, I know the fears of a sports tribunal because many times it takes away, again, in line with his principles of specificity of sport and independence of sport and what have you. It sort of takes the governance away from the federations, both national and international. Because now there's a sports tribunal that for me should not even be appointed. Under the Act, it's appointed by NCS. But for purposes of transparency, I propose that it's appointed, I don't know, by Chief Justice or something like that, or at a national level by a respected institution or something like that, or body or person of eminent, say, legal people, sports lawyers, judges, say retired judges or something like that, to have something like, so that we can have a proper trusted dispute resolution mechanism as it's happening in Kenya. Yes, that body may not be perfect, but I believe it has improved Kenya's lex sportiva, but also improved the governance of sport in Kenya in many, many, many aspects. For example, it is clearly laid out as far as the jurisdiction is concerned that when it comes to this matter comes here as a court of first instance. It's a contractual dispute, etc. If it's, for example, a doping dispute, we can start, for a contractual aspect, it will start from the national federation's dispute resolution mechanisms. Then if you're not satisfied, you'll appeal to them. So they'll act as an appellate body. But for example, when it comes to doping, I think there'll just be a court of first instance before they send you to either CAS or WADA, I don't know, something like that. So the jurisdiction, proper regulations laying out how this thing is going to function. But for me, importantly, let us take it out of the control of NCS. Let us have it. We have decided to regulate sport as a country. We cannot pretend that we cannot have a tribunal. And I know the fears around a tribunal, but let us have a tribunal, a sports tribunal. And that will, for me, if anything, take sports matters out of the courts of law. Out of the courts of law completely, and also shall have proper sports people there, people with skills, proper skill set and education in the area to determine sports disputes. Because yes, sports disputes are very, very bespoke given the nature of sport. A sportsman has a short shelf life. You don't want their matter lasting in court for 10 years. No, once the matter be resolved, can I appear for my country? Eligibility, if it's doping, the doping matter be resolved very fast and I go and appear in the Olympics, etc. So things like those. And also I want an outright acknowledgement or submission, CAS, in the act. Like we've said, CAS, there must be some sort of agreement, either through contractual or again through a legislation like this. You can submit to CAS and say CAS will be the appellate body for all disputes from the sports tribunal. The same bill also seems to limit what is a sports dispute. It limits it to very few disputes. There are very many sports disputes that can come about. It only says a dispute between the council and the National Sports Organization, the National Sports Organization and its members, and between sports organizations. Disputes around doping, disputes around contractual issues, disputes around, eligibility issues, selection issues for national teams. Things like those should be able to be handled by that tribunal. So let us increase the scope of what amounts to a dispute in sport. That's my submission on the tribunal. Offenses, of course, the offenses are good and in line with international developments and trends, commercial rights, electronic media production, like what FIFA is doing, broadcasting issues. But again, we, yes, are attempting to be professional, but we should sort of trudge a bit careful when it comes to this, because we are trying to promote sport as much as possible. We are trying to encourage sport and make it as widespread as much as possible. So the limitation should be a bit careful or phased until we reach a certain stage. We're still at an amateur level largely as far as the sport is concerned. I think it's only football that's properly paid. The rest, no, not really, except for one or few teams here. And also football, because football is big. I mean, the money that goes to FIFA is crazy. Like Dave mentioned earlier, it has more membership than the United Nations. So it can afford to fund its federations, its member organizations, all of that. And as a result, that money can trickle down many times, and people will earn crazy, whatever money they can earn. Good salaries. I'm sure Dennis earns a good salary. So we should be careful about that. And because and actually, when it comes to many of these federations, people are actually more or less volunteering. And that's another problem, by the way. Because of that volunteering, many guys hold everyone else at ransom. You know how much I've sacrificed to be your president over the last 10 years. Therefore, they can get away with anything. So things like those. But for me, commercial rights, and they're properly defined. I like the fact that Mr. Magogo defines them, image rights. Maybe this is our chance to legislate on image rights. I'll suggest that we properly legislate on image rights through maybe regulations or increasing through create another provision under the bill that properly lays out image rights and how they should be as far as sports is concerned. Because this is very controversial. We've actually had a judgment recently by Justice Sekan in image rights, but it was because I think the prosecution of the case just came short a bit. But it was a good one. It was a step in the right direction. So it shows you that we are moving towards proper, professionalization of sport, because people now have realized their images are big. So yeah, he defines them: audiovisual rights, new media, copyright, etc. But again, let us tread carefully and let us define through regulations properly what amounts to an infringement of commercial rights, electronic media rights, etc. Like what FIFA does. FIFA lays out. I mean, for example, if I even retweeted a clip of the UPL, I may be in trouble with FIFA. So if I posted on my social media, for example, I may be in trouble with FIFA. So it has properly laid out and break down what exactly is allowed and what isn't allowed. And thankfully, there's a provision for regulations for some of these things. I'm more or less done with the Magogo bill, and as I've been discussing, it has been recommended. So, but now let me go into the pass bill. Then again, we shall come back maybe at the end to see whether there are any similarities or any divergences between the two. But the minister mentioned again that they had sat down to reconcile the bill. And if you go through the two bills, the pass bill, that's the physical activity and sports bill, and the Magogo bill, which is the national sports bill. And indeed, if you look at some of the provisions, especially towards the end, they are more or less similar. Only at Magogo, for example, defines commercial rights. President Honorable Magogo defines commercial rights, which is not defined by the sports activity, the pass bill. And then these ones are all reproduced the way they are. There are some differences which I'm going to go into when I discuss the pass bill. So that is a discussion as far as the Magogo bill, but let us discuss the pass bill also, then we shall come back to discussion. So physical activity and sports bill, for me, I have a problem from the start, and apparently this bill has been in Ministry of Education on the shelves of Parliament, hidden somewhere for about 12 years. I don't know why, but also just the wording. The wording speaks to a major conflict in Ugandan sports and its governance. Physical activity and sports. Why are you lumping physical activity, which is gymming, walking, skipping, and all the other activities that amount yoga with sports? I mean, that is a major problem that should be addressed. I mean, sports is a multi-billion-dollar activity that has gone beyond just some kid in the village kicking a ball and enjoying himself to something that earns and literally can even overthrow governments. That is how big sport has become. Mm-hmm. So that one is the first problem. Why mixing up the two? Federations under this bill must be incorporated under the Companies Act as opposed to the NCS regulations. As opposed to what the NCS regulations stipulated. Well, they had said any form of incorporation, but majorly the discussion was about trusts. And maybe I'll just correct that in my presentation. The discussion was about trusts. That why should you have companies, federations incorporated as companies as opposed to say trusts? Because a trust, for example, you're holding something trust of the general public, as opposed to a company where you have shareholders and directors. Meaning, if FUFA Limited, Mr. Magogo will be the owner and a couple of other people, something like that. So that could be a problem, but maybe it should be harmonized later on with the Magogo bill. But also remember the Magogo bill, as far as partnerships and companies limited by guarantees concerned, is also a problem. But it allows earlier incorporated bodies. In other words, if you are incorporated as a trust, as you transit into this dispensation with legal framework, you're allowed to exist. So that is another problem. You can have trusts, companies. Why don't you recommend something once and for all and say, be registered as trusts or be registered as companies? And that will prevent so many problems as far as especially litigation is concerned. Other salient aspects, it has a controversial provision that a former member of a board or council should not disclose any information during the course of employment for 10 years after they've left the job. This is a bit controversial. What are you hiding? Are you hiding something? That's a provision in bad faith that should be removed. For even when they're harmonizing and the second reading, it should not be considered at all. The much vaunted national recognition and reward system for outstanding sports personalities is finally here in this bill. And perhaps Magogo's bill should also incorporate it. Remember, the president said that I think outstanding sports personalities shall be getting 5 million per month. So perhaps through regulations, we shall need a proper breakdown of how it will work, how it will be governed. The pension scheme is also provided for outstanding athletes. The bill, unlike Magogo's bill, which says it uses may, Magogo's bill says may, you may institute a tribunal, sports tribunal, not shall. And I propose that in Magogo's bill, it should be a shall, mandatory, not directory language. Here, it does not even talk about the sports tribunal at all. Instead, the minister has made a court of appeal of sorts, the Minister of Sports, where there's a problem from a person not being licensed by NCS, they can appeal to the minister. So that is the dispute resolution mechanism that is there, which is wrong. Like Magogo's bill, it bars, like I mentioned, some similarities, it bars commercial infringement of commercial and broadcasting rights, but does not define them. My conclusion, as far as this is concerned, is let us include a proper provision on who a sports stakeholder is. This is controversial and has been a subject of litigation, again, back to Kenya. Sports many times defines who a stakeholder is. If you even go to the FIFA statutes, there's a definition of who a sports stakeholder is. If you go to the FIFA statutes, which are more express on the subject, it literally, me, Ivan Ojagola, has been a fan for a very long time. Even a journalist, perhaps, who's more in the arena, may not be a sports stakeholder. Coaches, sports people themselves, administrators, etc. So it sort of limits and puts out some people. So we need a proper public interest provision on who a sports stakeholder is, who should be I and all and sundry, as long as it's Uganda. That is my provision. That's my suggestion. And this has been litigated in Kenya. The first case, when Mr. Mwenda was trying to object to his being investigated, he said that the whistleblower who had brought the claim or who had reported him to the CID, equivalent of CID in Kenya, was not a stakeholder. But he was saved, the whistleblower was saved by the fact that there was a provision there in the Sports Act of Kenya, what they call the modern Kenya Sports Act, the new Sports Act in Kenya of 2013, that actually made him a stakeholder and can look into the affairs of FKF. So we need a public interest provision like that. Incorporate a formula on allocation of monies to different sports federations. This is why NCS is before Parliament right now. Parliament said that beyond the appropriation of the monies, we're also telling you who should give what amount of money to. And that has caused some problems. So even the so-called priority list, I think there are about 8 sports. Mr. Mudabe will expound on them. We need a proper legislation. Let them be in legislation if they're supposed to be there. Of course, that could be problems going forward, but we don't want things just being said priority list, and that causes so many problems in the sector of favoritism, of bias. Corporate governance is of the essence. That is perhaps the biggest problem. And when NCS is before Parliament right now, that could be the major affliction. Consultation, and more consultation. Don't rush into this bill yet. Harmonize properly everything thoroughly, and then we come up with a comprehensive, thorough bill. Thankfully, they've called for those interested to go and make their submissions. ULS is appearing on Monday, but whoever else thinks they can submit, please find a way of going to submit. But importantly, wait for that NCS report from the probe. That will define so many. As far as I'm concerned, that report, if done thoroughly, could be defining. It could define the sector for posterity. Thank you very much, ladies and gentlemen. That is a summary of my presentation on the 2 bills, and I'm looking forward to a discussion after this. Mr. Munabi, over to you.
Thank you, Ivan. I'm very impressed, and it's been such a wonderful presentation. However, on your very last slide, I've had an interaction with the president of Uganda Sports Press Association. He was on the same point. Where does the press fall? Because as you have seen in the struggle for developing sports from the grassroots, we have people who have invested in sports. A person like Next Media has even put up a sports TV. FUFA has a sports TV, and so many other people. We have some who close business, but still there is effort to see that sport is uplifted and put outside there. Just like we are here, if we don't have such platforms, many of our colleagues cannot appreciate that there is a segment and sector of sports law that is this developed, that is this active. So until we put up such platforms, there are 2 burning hands, one from Segwani Saka and Rosemel Kanowel. I don't know if they're still online. I wanted them to air out their questions. Before I bring in Dennis, I know he's there. You said he drafted the Magogo bill. Rosemary Kanowel, are you online? Can I have Rosemary? Saka Segwani. You're permitted to talk. Please unmute and participate. If they may not be ready now, I'll read out a few comments. Ramadan Majid says, this comes at the right time with the World Cup mode on. It's an interesting topic. Yes, sports is quite interesting and very rich if you participate in it, if you interest yourself in it, more so the practice and the legal aspects around it. Is Dennis on call?
Yeah, I'm eager.
There's a hand by Timothy. Let's get the comment or question from Timothy, then you can come in.
Okay, right.
All right.
Okay. Thanks for the presentation, Ivan. My question or my reaction is on the Magogo bills, especially when you go to the offenses bit, where from broadcasting to entrance of into sports events without maybe the right authorization, to using sports results for betting. What you could see there is that they try to make all these national, yet they are also aware that we kind of operate in an international sports ecosystem. That's why from even reading from the FIFA statutes, you'll see lots of reference being made to FIFA itself, the mother body. Now, my worry or my concern is that while drafting this bill, all effort is concerted at national level. Then one would ask themselves, how would we then, if even we are looking to go regional at East African level, even at maybe at continental level, the African Free Continental Area, which is also drafting its own protocols on intellectual property, how then can we integrate? Yet the bill that we are mothering at the time is all concerted on the national space. That's my concern. And if maybe Dennis could come in, could throw some more light on that, on how then we'll look forward into integrating with the global village, yet the bill that we are currently doctoring is all concerted on at national level. Thank you.
Thank you, Philip. Thank you, Timothy. Thank you, Ivan. I've been listening to the submissions of Ivan, and this time round, I was not even listening to prepare a response. But first of all, I want to appreciate that somebody invested time to scrutinize the bill and come out with very, very brilliant provisions. Thank you so much, Ivan, for that. However, first of all, I also sat in some meetings, because this was a private member's bill. As a member of parliament, they always engage researchers from parliament, but they always consult you, having worked for football for some time. But my opening remarks on the bill will be very brief. One, I want to invite and also encourage, especially, I'm glad that most of us here are below 10 years of practice. And in the entire world, it's always encouraged that before you benefit into something, before you become Messi, before you become Ronaldo, before you become the best judge or a judge of a high court, as the minimum, you must have practiced 10 years from legal practice before you join the judiciary as the judge of the high court. So even as we try to, if we go ahead and involve ourselves as land lawyers and develop this industry, money will be automatic in a period of 5 to 10 years to come. So I want us to look at everything from scratch and we develop it together. And I want to thank Philip for that. We don't want to line behind. The big law firms we are looking at, some of them have been in practice for the last 30 years. Some of us were just starting 4 years, 5 years. So we need to develop this industry. And why am I raising that? We need to look at this bill with both hands and both eyes. One, I want to inform you that this bill is coming up, the Magogo bill is coming up to try and answer some questions that were not answered since 1964. And you need to appreciate that. Over 60 years, nobody was talking about it. We tried to, FIFA tried to raise it in 2014, where there was issues of FIFA Limited and others. what the best that could come out was the regulation. They called the SI 38 of 2014. And that SI was trying to answer an issue of corporate personality. Are federations legal entities, or they are just loose associations that cannot be sued? And Ivan, you mentioned it in your opening remarks, that whenever we could go to court, federations, we are like, you guys, you cannot sue us. We are a loose association where members come in and move out anytime. So the SI came and said, okay, we have brought for a solution. Federations, you can register with National Council to be recognized, but on condition, you must be a corporate body. Okay, we say that's good. We are now going to answer questions where FUFA Limited, Magogo owns the company, are going to be resolved. However, this SI, with all intentions and purposes, stated categorically clear that before you become a body corporate, however much you want to be a body corporate, you must not be a company. I said, now, which kind of cross-cutting is this? They were targeting certain federations and said, don't be a company. Now, when you go into national laws and say, okay, an association of 150 members, how do you become a body corporate before becoming a company? You either go into an NGO. Now, football or boxing is not about NGO. The rest is corporate society. We don't fit in there. So that's why you see every federation had to go into trustees. And colleagues, do you know where we register the trust? Ministry of Lands. That's where you go and register. So you need to understand the intention of the drafters of the Trustees Incorporation Act and why they took that into the trustees, the Ministry of Lands. Is it really about promoting football? I mean, promoting sports to the international arena, sponsorships, marketing players, signing sponsorship deals, broadcast, and then you are regulated by Ministry of Lands. So we need to review that. And Ivan, I established that in your closing remarks, you try to support the issue of trust. Yes, if you have a trust in a different setup and not going into the Ministry of Lands to regulate as if this is a land matter, then we'll have an issue about it. So we need to appreciate the background to that. Now, when it comes to this Magogo bill, you understand the intention was, can you have something to start with such that we answer the pet questions? The first pet question is, how can associations, boxing, athletics, football, how can you become a body corporate such that you can transact, such that you can own land, such that you can sue and be sued as an association? And remember, government is just coming up. For those of you who have been following this game for some time, government is not, he has not been in the game for the last 10 years and so. The time I was at university, people, individuals were sponsoring national teams to travel out of the country, for your information. And some federations at the moment have not traveled because government has not invested in money. So you can't rule out the issue of private individuals. These Mlindwas were putting in personal money for a team to go and play. Boxing, some boxers go and even disappear, not because they want, because they don't have that enough support. So as we try to invite government to come to sponsor national teams, mind you, if a club, for example, Vipers is going to play out of Uganda, that club is sponsored individually. Mr. Mlindwa puts in money. But when the club reaches out of the country, it is representing the country. We've not even reached there. There's no money that goes to football clubs. But when the bill was starting, for purposes of brevity, to summarize, there were two issues. The first bill was highly detailed, as Ivan would wish and Timothy and other members. Actually, where the first bill of Magogo was introducing what we call a sports authority, the way we see other authorities, the UNILAS and other institutions which are independent, fully financed. But now you need to understand, we have, if you are talking about this bill, Ivan, my colleague, you need to understand the balance between politics of this country, administration, and then your industry as sport. One thing you have to know that we have a physical department in the Ministry of Education. We have a physical department, something is physical education and something. And now this is about physical education. I think this is what we call PE. These kids learning around, remove shirts and run around the stadiums, just for fitness and that stuff. There is a full department for that. Now we have National Council by then, basically, the rules that are governing them now was about what we call amateur sport. You highlighted very well. It was about amateur sport, not professional sport, where a boxer is going to go and $1 million come invest, fight, all those elements were missing in terms of professional sport. Now, when you bring a bill and you want to take away those departments, I think now you know what I talk about when I mean politics. Some people are losing jobs, for example. You can't just come and you think they will keep quiet and lose their jobs. And this is my personal opinion. Because when you bring an authority, it means you're going to cover and leave some institution. The authority was even make, for example, repealing National Council of Sports. So the bill was not targeting changing the status quo in terms of sport. It was basically to come out and give the basic rules that you can start with. And these are like 5, as you mentioned. 1, how can regulations, federations and associations be incorporated to be a body corporate? 2, what are the offenses? Those offenses that really are trying to stifle the game. And then 3, international federations. How do we reconcile? The question that Timothy answered. Now, when you talk about the details of those elements, they are going to ask you, Mr. Magogo, do you have a certificate of financial implication to bring this bill with the tribunal who is going to sponsor it, who is going to sponsor the authority, who is going to sponsor this, we don't have money. Automatically, it will die immediately. So Mr. Magogo went back and said, okay, can we remove those elements that require investment of government and then let us first have the basic? Because when you talk about incorporation of associations, who is paying? Government is not investing in money. For you to set up the offenses, government is not investing $1 billion to set up an authority, hire employees, all those sorts of elements. So he said, okay, he had to succumb and remove all those where money was going to be paid by government, because you may not easily get a certificate of financial implication. So we have to remove all the elements. Now, the things you see here are basic. And what the intention is, can we have something? Can we start with this? Because even Companies Act, so many acts, they keep on being amended all the time. So the first element is 1, if you want to deal with the National Council of Sports, as I even mentioned, and set up, for example, a sports authority like Kenya, then that authority needs money, needs a budget, needs employees, which are also happening in National Council. So it's like, okay, National Council can stay because it's not really a dilemma. It's not really something that is difficult because they can deliver the game. So let National Council stay. So Ivan, that's the reason why National Council had to stay at the moment, because once you want to change it, Ivan, they will tell you get a certificate of financial implication, ask whether Minister of Finance has the money to set up a different authority, all those elements. The second element you talked about was incorporation. What you have to appreciate at the moment is how do federations incorporate? And then you need to appreciate colleagues and the lawyers here, even the senior and junior, and those who have not practiced for some time. There's a difference between a federation, there's a difference between organization. How are they different? 1, we have associations which are individuals. When you are traveling with a national team, for example, boxing, these are individuals with coaches. But when we talk about, for example, football, they are clubs. Club, we find Villa has another members in it, so we admit a club, and then those clubs federate. They come together. We don't, actually in football, we don't regulate each particular individual. We regulate other associations. We have 8 regional associations. Eastern region, they have their constitution, they go to every district. So those are the people that federate together. So in the bill, if you come with only a federation, you'll find that you are leaving out some. And this bill is targeting either 56 federations or associations. So some call themselves associations, others call themselves federations, others are calling them unions. And you see, it may be terms of what we call nomenclature, the naming, but inside their constitution, you find they are different. A union may be different from an organization and may be different from a federation. like we have rugby union, you may find you have golf union or some other things. So it tried to capture all those. If we get a better wording, because this is a private member and I'm also not an expert in legislative drafting, we welcome those ideas such that we look at it together and clean out those few ambiguities. There's an issue of, you talked about deeming partnership and limited. Yeah, I think he was trying to raise an answer, but it was left by the drafting guys from Parliament, the Department of Legislative Drafting, for reasons that I have also to appreciate. But the issue was, they were trying to explain an element of a federation or an association should have an element of a body having legal capacity to transact on land, and these are private in nature. So I may not dwell so much on that. It's, as you said, we can always clear it out. I don't think it is really a deal breaker and relevant in that. But the most critical thing I want you to appreciate and find resolutions from this legal cluster. We are over 100 and 200 people, those who are interested in the sport. We have the reporting system. We have football, we have basket, we have 51 federations or associations. And you all know these have to be compliant with national laws. Parliament cannot regulate something and then you think that you will be a FUFA and you'll be out of the law. You can't. You have to be compliant with the national law. On another day, we'll discuss what amounts to interference. But the regulation is FUFA, you must be compliant first with the national law if you want to be recognized. Now, what we are asking is the reporting system. Ivan, you are very categorically clear. Why don't we go into companies, or why don't you go into trustees? We are saying, okay, the role of the company is the company corporation and its regulations are governed by Companies Act. There are issues of, if it is by shares, there are issues of dividends, and now associations, be it boxing, not at any time the intention is to share profits, not at all. So it means you are going to leave us with only company limited by guarantee. Now, when you critically look at company limited by guarantee, resolutions, leadership, you may find their issues, but we wouldn't want to comply with companies because this is not a business, it's not basically a company that intended, associations are not basically intended to comply with issues of companies, resolutions, minutes, allocations or allotment of shares. We want to go to National Council and tell them, we are FUFA, we have 34 members. This is our constitution, these are our members. Can you please register us? And once we register, we want to be a body corporate. How are we coming with this? FIFA itself, the international body, you go to Zurich, the registrar's office, and say we are an association, not a company, not an NGO, not a trust. We are an association. Please incorporate us. Once they are registered, they acquire what you call a corporate capacity to transact. In Uganda, if you look critically, as I summarize, it is more of how you see political parties, FDC, NRM. Once they take their constitution to the, as if they under the act, the Political Party Organizations Act. Once FDC registers or NOP or NRM, they are saying, okay, NRM, you are an association of 1 million Ugandans, but once you have registered, we have given you a body corporate capacity. NRM can sue you, NRM can buy land, you don't have to be a company, you don't have to be, so that association in accordance with your constitution. So our target is, can we report only National Council and comply? These are doing business full time. So they are doing sports 24 hours. National Council, we are FUFA, we have brought our constitution, books of accounts, leadership. Can you please register us? Now, once National Council registers the association, that association become a body corporate. That's one of the targets in that bill, if you look at it critically. I don't think really we have to go into companies, trust, Ministry of Lands, go into corporate societies, let National Council resolve, because it can know this is amateur boxing, this is professional. How do we deal with it? You can't deal with that issue in the ministry at URSP. It is really not really green light. The last one is about offenses. Yes, the offenses are not very detailed, but if you look at Magogo's bill, he tried to highlight that the minister will have to regulate. Lawyers, if you want to do this bill and leave out the political wing, the minister and the National Council, you will go back another 15 years to come out with this bill. So each body that is existing, Ministry of Sports, National Council, if you want to start something, you need to leave them with their powers. So the minister will set up a regulation to guide, because some of the things you are talking about, like broadcasting, partly are covered under the Corporate Act, the Corporate and Neighboring Act. We have a trademark. So we believe it's like we have a trademark act and the trademark regulations detailing how a trademark can be. So even these offenses, the minister was given power to highlight, go and do research with Munabi and Ivans and come out with a provision on regulations. How do we regulate about broadcasting? If you broadcast for education, news, that cannot be an offense. But Ivan, it's be appropriate when you organize a boxing in Lugogo. People are investing their money. You bring your camera, you switch live. People are getting views. YouTube is paying you. By the time I go to court, it's already late. We want that offense to come. When we find Timor with a camera at Lugogo, streaming live a boxing match where people have invested in money, we can use that police immediately. That Ivan can be kept somewhere. Then we will go resolve the issues in court. But when you rely on the Corporate Act and Trademarks Act, you may never resolve these disputes. So I believe on Monday, I don't know which team is traveling. Those are the basic things. Can you have something? If you can guide either Magogo or the Law Society, can we start? I want to respect Ivan's opinion that we need to wait. Mr. Jakolo, we have waited for over 50 years. This thing is not coming. If you leave this thing to some technocrats, as you know, our environment, as lawyers will not have any progress, we will not provide any support to this industry. Let us have those basic. We can keep on improving. Companies Act, trademarks, they keep on improving every day, such that we can start. For me, that's what Magogo is thinking. When you talk about the past bill, yeah, you read it. I didn't give it time, but realize it is bringing issues of physical education. It has amateur, and there's no line exactly where we start from professional and amateur. The idea was in the Magogo's bill, let the ministry remain with physical education and amateur, for example. Let a professional game be taken somewhere like other countries. For purposes of time, that's what I can say, but we are looking for the support to start. This government is a very good government, but when you leave this industry to people, because we all have an issue of competence, experience, not in judiciary, not in lawyers, not in ministries. The devs who discuss this in the morning, these guys have practiced for 20 years. These things are on their fingertips. I, Dennis, who is trying to be among those who have an idea, I've learned on the job the last 4 or 5 years. I learned on the job, read what other federations are doing. But if you want this bill to go further and then wait another 10 years, we cannot tell it. Over to you, Ivan. Philip.
Dennis, I think Councillor Irumba is still online. He had a question. He needs a comment on sports betting and guidance whether our legal framework as it stands is good enough for us as a country. I think in terms of sports law and sports betting, he needed a comment on that. If you can do something small, because sports is largely into football than any other sports around.
Yeah, one thing I can comment together with the Timothy's question. Timothy was asking, where are we living international federations? Timothy, if you look at the bill, Ivan mentioned it, that we are recognizing one thing you need to understand. The Parliament of Uganda cannot regulate beyond out of Uganda. I think that is the basic. You cannot regulate what will happen in China. If Uganda cranes go to China, you maintain so you only regulate within your jurisdiction. But Ivan brought it out that this bill, Magogo's bill, is trying to raise that we need to have a clause respecting the regulations of international federations. And that's categorically clear. That is the FIFA, that is the international boxing, international athletics. We need to have a clause that their rules are binding on the athletics and federations in our countries. So that's the best you can do. Otherwise, you can't finish 51 federations in the world and others, and then you try to capture everything in your bill, you'll have a bill of over 1 million pages. So, but if we recognize that would be on the issue of sports betting, yes, we have companies here which are in the business of people betting and earning money. For us, that's not the problem as sports. We have two problems. One, we've got individuals who go and bet $1 million or $1 million or 100,000 US dollars on a game, for example, between KCC and Vipers. And then they want to make that happen. They now go and approach players, referees, and infiltrate. Tell a coach, for example, a referee, make sure you give a fake penalty such that I earn money, we will share. That's the offense we want to go into. Now, for you, this is like a sex offense or murder, all those offenses that are not done in the light, they are done in the dark. They are committed in the dark. You need government such that you can investigate in detail. Secondly, some sports betting companies, they will try to make sure that they also invest, because you come and put odds on a game between KCC and Vipers, for example, or between one boxer and another boxer, that Philip will win. And then Philip is not benefiting anywhere. So that's like what we call unjust enrichment. You are earning on some people's fight. These guys are risking their life. They have invested the fight. You step. We want either to get permission from the Boxing Federation that your fight will be on my page and people are going to make money out of it. Either I give you a percentage or we can agree otherwise. But for you to place those fights on your page and you are making money, and then me, the person investing, because that will not make sense. And we want that to be regulated. The offense of manipulation, because if a boxer is given money to accept to fight poorly, and then the other one win and somebody wins money, is illegal and is cheating, and really has to be an offense. And also placing people's effort on your platform is just unjust enrichment. That's what I can talk about now.
Thank you. I don't know if Ivan has any rebuttal to your comments.
I don't want Ivan to rebut. I want us to really have harmonization, because rebuttal looks a bit. One thing I want to request Ivan is to understand the background, because he really did a great job to read and analyze. We don't have many lawyers. And Philip, I understand you have a say in the sports law cluster. We need to know the lawyers who are going to Parliament. The background is key. Thank you.
Dennis, I'll not reply. Yes.
I'll liaise shortly. I'll liaise with the Secretariat to know which lawyers are going. Maybe if a person like Dennis is not on board, they could miss out on a lot of things. Dennis and Ivan, actually, because me personally, I'm for the old law.
Yes. But I sort of agree with you, Philip, because honestly, regulation the sport is going to be very tricky. And I like Timothy said, I mean, it operates. It is a very slippery area, and we should be careful. But I understand we need something, but still, with all his divergences around the international nature of sport and its independence, it could be very dangerous territory. But nonetheless, let's see what we can come up with. But just to Dennis mentioned that we need a provision on international affiliation. We have one actually, clause 64, particularly 64.4, that says those national federations the interpretation and application of this act shall recognize the provisions of the statutes and regulations of the international sports governing body, which a national sports organization is affiliated. So we have that one, and perhaps it can solve some things. Yeah, but yes, again, for me, it's a bit tricky, but nonetheless, there's a law. Let's see what we can work with. And also for me, what has come out from this discussion, the politics around sport, and that could be the major stumbling factor or stumbling block for us to have proper sports legal framework. The politics is crazy. Even National Council, people blame National Council for so many things, but how much has the politics empowered National Council? If indeed it is to be awarding recognition, incorporation, and registration certificates, don't we have to have a particular provision stating that outrightly? And I think that's something we should incorporate, or even an amended National Council for Sport Act that properly gives them the powers to grant such power, because that could be another lacuna that could come out in case of any litigation. But nonetheless, I'm happy with Dennis's discussion, and hopefully we can maybe because I know ULS is also collecting views from us. So hopefully we can have a harmonized position as ULS going forward, so that we can have a proper presentation on Monday. Yeah, but for me, the politics. I don't know how we shall overcome it, but that is the biggest problem in sports.
But you see, where politics is at play, I mean, you saw how the chairman and the secretary and the minister were splitting each other in parliament yesterday.
That was unprecedented.
Very. I'll read out a comment from Wilberforce Wambale, who says, "Thank you, OJ. I believe the Magogo bill is instrumental. Though regarding disputes, we would borrow the experience of Egypt, where National Olympic Committee is tasked to handle it." It's a bit controversial also, because here, like Dr. Rukare was chairman, National Council of Sports, and president, National Olympic Committee. So I think sometimes there would be controversy and conflict of interest in a way, more so when these two bodies are at play, UOC and NCS. I've seen a question which I wanted to give highlight on. It's from Tracy J. Amon. I hope he's online. He says, "My question to organizers: what's the current fate of kickboxing and the Uganda Kickboxing Federation?" Now, some of us who have been into sport for quite a while, we have realized that there is always controversial leadership at almost all federations. Every federation has one president supported by UOC and another one supported by NCS. How they get to harmonize, like for us, how we did it in boxing, we had to push for the International Federation, which is IBA. We had to push for the Confederation Africa region, and National Council of Sports had to buy into the fact that we were the duly elected council in leadership. We had about 7 court cases contesting our leadership. Kickboxing has had this dilemma for quite a while. At some point, they had 2 people assuming office of president, but I believe they will harmonize and get proper leadership. That is when their recognition will be uplifted by National Council of Sports.
I have a question.
Yes?
I have a question for Dennis. What does Dennis think about a sports tribunal?
Dennis, are you online?
Yeah, I'm online. Yeah, we thought about it in several meetings, but one thing I want to tell you, and this is my personal opinion about it. We wanted to have, Philip mentioned something like, we can make something like that where we have professionals in that game. One thing you want to understand is that one of the issues still to have an elaborate tribunal was, if you have 10 lawyers and they are, how you can see, for example, the labor court, these are the level of a judge, they will tell you need a certificate of financial implication to set up that. So we left the Magogo bill, try to generate something really for the start, have somebody that let it be appointed by National Council. Because anytime you want to shift the powers, I don't want to use politics in a negative way, but still you realize that you are killing yourself. You are not moving. It's like, okay, let us have a tribunal, but we believe that in the future we need to have a tribunal with competent people. I tell you, we go to court. Right now, we go to magistrates' courts and some legislators and judges or magistrate tells you, this is not something I've practiced before. So it's not something for gambling. You need time. You need time to really appreciate. That's why you see even FIFA and other federations, they get people like Dave to come and talk about issue like doping. Ivan, just wake up one day and then you have an issue of doping in this country. A boxer is being rejected to participate because of doping, and then they disagree. You go to the tribunal. I don't know very many people here who can handle such a dispute. So when you want to escalate it to handle all the disputes, at the moment you may have issues. So, but we believe, one, to avoid the issues of financial implication and sort, we are like, let us start with what about disputes among the federations, and then those federations will pay in a regulation that will be set by the minister. If I have a dispute in football with the Philippine boxing, we contribute to the panelists, we contribute to their best financial reward, and then they make a dispute, a resolve a dispute. So basically that's where we are, but still we believe, where can we get the competent people? Can we set up the labor court where it is headquarters of that body? What do we do to avoid the issues of that? Ministry of Finance does not have the financial element to cater for it. That's why I can talk about it.
Philip, just a follow-up question very quickly. There's a doping committee in the Magogo bill. In the past bill, it is called the doping organization. So did Dennis and Magogo, did they envisage a doping committee with quasi-judicial powers or judicial powers? Because if doping is very technical, like it says, and indeed it is, what does they envisage?
Ivan, at the moment, we have the WADA. It works closely with the National Olympic Committee of Uganda. And actually, that committee handles basically those places. So that committee actually is in existence, basically handled by Uganda Olympic Committee. And then even FUFA, I remember one coach appeared and some player appeared before that committee. It is also supported by the regional association, the regional committee. So what we are lacking is only the legalization. It does not escalate so much into the issue of government to pay those members, but still, it's not recognized in the law. You may get a judgment, and then the courts of law or the federation refuse to respect it, and then you find you have to rely on FIFA or international federations. But the body is there. We need to know how it works, but it's there. I've appeared there before, or for some issues. But the judgment from that committee, what we are asking Philip and the members, how can we implement it? Because that committee can reject a player, a boxer, and then Philip says, that's not binding nationally, I will continue to use the player, and then we wait sanctions from WADA, the international body. That's what I can talk about.
I see a question from Alex Adupa. He's asking on how to open a boxing club. I don't know if he's particular with the boxing club, because he says, how do you bridge the gap of the cost of forming a boxing club and the requirements from National Council of Sports? Maybe for guidance, if you want to open a boxing club, and that is what your question is about, you can go to the Uganda Boxing Federation offices at Lugogo MTN Arena. You'll be guided. It is the Boxing Federation or the Football Federation or the Swimming Federation that is in charge of the clubs. The National Council deals with the associations or federations at the national level. I have your email. I can send you some more details. I see a lot of nice comments. Natural Sharon says it's an interesting discussion. Emmanuel Swama says it's a great presentation. Margaret Naiga is also impressed, says it's quite impressing. Warren Biamukama says very insightful discussion. I see Timothy's hand still up, and Rosemary has put down her hand. Segwani says, hello discussants, I'm in class following the discussion. Well, thanks for the wonderful presentation. I must concede that I have totally been green in the sports area, but I believe that at the end of the day, it will be different. Yes, it will be different. Some of us have come early. It's quite painful. You do most of the work pro bono, if I may use that language, but it's a lot of learning. It's a lot of good experience. At Uganda Boxing Federation, we have recently had the International Boxing Association is going to set up a 10-acre. We were given 10 acres from Buganda Land Board. So we are going to set up a sports complex like the one in Chetume. We also need to empower our members in that field. So sports, like I always keep referring to the President Magogo's comment, is a multi-billion industry. It's just silent, but those who have opened eyes to different areas of practice, like Lukambi referred to the farms that have been around for years. I mean, if a farm has empowered itself in oil and gas, in mining, in PPPs, why don't we as a generation look at something that is going to be productive 5-10 years from now? That is why some of us have been early into sports. There are some introductory courses like sports administration course, which is currently ongoing at Uganda Olympic Committee. There are some arbitration and mediation courses, mostly in Kenya. I've done 2 courses, one on mediation, sports mediation, and one on sports arbitration in Kenya, SIAB and Sport Legal. There are so many workshops and sessions that I'm always invited to by Dennis or FUFA. I say Dennis, but FUFA always sets up certain workshops to empower its members on the developments in the sports field, mainly football. Maybe as time is moving by, we have 10 minutes. I'll invite some more questions. Warren says, is there a federation for sports betting? Not really. Sports betting companies are private entities, so they are not under any federation. I'll invite a few more questions.
I have one more question for Dennis. it's about it's about the broadcast rights, the intellectual property rights. How do you balance? You know, this is a problem with sports. Originally conceived as a public interest thing for everyone to enjoy, but now commercial interests are taken up. So how are you going to balance this thing, Dennis? Because now journalists, for example, are going to struggle getting some of this footage. Even us, just recording Alan Okello scoring a goal, EDC, and I may have to get authorization. Yes, FUFA owns the football product in Uganda, organized football, that is. But how do you balance public interest and your commercial interests?
We are, one thing I want to tell you that we are learning, personally as a lawyer, I'm learning a lot started learning. I joined the federation in 2016-17, and the first thing I was doing is to read the legislation in South Africa about how they handled it. So to create a balance, yes, we have the public and the private. What normally happens, look at a club like Vipers, or any boxing club, or a boxing match in Lugogo, where we are familiar with, where somebody has invested, hired the venue, paid the boxer, sometimes even pays tickets for boxers to come and attend the match. And then this match, yes, a Ugandan is fighting against a Burundian. But the cost of investing that match alone, sometimes I can tell you that these guys don't even make a profit, but they are developing what we call the brand. People always come in big numbers. So we are saying, okay, since I've invested, it's like a song now that Chameleone have initiated his song. It goes to America and we say our Ugandan is on Eddie Kenzo, is on BET Awards, but he maintains his rights as far as concerned. But when you broadcast for news, then you are not against the law. When you broadcast for education, not against the law. But Ivan should not come to a boxing match in Lugogo with a camera and the phone. Is streaming live. People will subscribe on NTV Sport, will stay the go, because by the time NTV Sport comes to capture that footage live, they have agreed with Uganda Boxing Federation, which has organized the event. Now, I don't want Ivan, the rules are, Ivan should not come with an iPhone 15 or 14, and then stream live, then he gets views, then YouTube is paying. So that's where you need to understand the balance. That even some of the national events, you have to subscribe on GSTV, and then in turn, GSTV pays Boxing Federation. So the line is educative, free of charge. And then the issue of education, free of charge, but don't get commercial out of it being national rights. We will have a discussion on another day, broadly, and we tell you that right now, that's the same thing that FIFA is doing. You can't streamline an England game live, even when you're from England, without the authorization of FIFA, yet the English national team is playing on Saturday. That's what I can say for now, briefly. But it's a huge topic. And those are the things I wanted to discuss, if that our time is running out, to interest the lawyers who are here. That one, there was a great topic of emerging areas in sports law. But when we talk about Uganda, we are here like over 200 members. We have our practicing certificates. But you know your practicing certificate may not take you out of Uganda. If you go in another country, there are rules. They've mentioned it, and I also am trying to interest our lawyers. Representing in Uganda, the dream of every player, including some of us, our dream is to go to Europe and earn a bigger chunk of dollars and pounds. But our PCs may not enable us. You have to go and enroll back for another few years. But when you get the FIFA agent license, which is coming soon, the first exam might be either in February or March there. Ivan, Timo, if you are interested, your PC may not take you to transact in UK, but that FIFA agent license, you can represent a Ugandan player in England, and you come back with $30,000 or $100,000. Something lawyers have to appreciate. You may not go to UK for legal representation, no, but you represent the player as an agent. Being a lawyer alone does not qualify. You will not go, they will ask you, who are you? I'm Mr. Lukambi Dennis, I'm a lawyer in Uganda. They say, sorry, your PC does not apply here. But when I appear and say, I'm Dennis Lukambi, a FIFA agent, this is my license, they will give you a platform. They cannot stop you from representing a player on a certain issues. Image rights, litigation, we've had some good judgments, others are interesting. Sponsorships, Philip was hit. We have NBA Sport, we have FIFA TV. In the near future, you're going to see a lot of real issues. That boxing, you are watching it for free now on NBA Sport. But in 5 years, it's going to be premium, I can assure you. Unless you pay good amounts monthly to watch DSTV or other things. Right now, the game is developing. Lawyers who are here in 5 years, I assure you, money may not be that a huge issue. We'll be now creating other issues to see how we contribute to the country. That's what I can answer in detail, and to close that from me, over to you, Philip.
Thank you. Maybe for members who are new into this area, there are a lot of opportunities, endless opportunities. They may not be paying off right now, but it gives you pride. For instance, I have advised on the International Boxing Federation arrangement with the Buganda Land Board on obtaining the land in Matuga, 10 acres of land. I feel that pride, much as it was free of charge. I feel that pride because my name is indelibly there. It's going to be a $5 million project that is going to start anytime from now. So it is a lot of opportunities. Like Dennis was saying, sponsorships, engaging in studies, engaging in so many activities. I've had chance through sports. I've had chance to participate in Olympic qualifiers in several countries, just because of my interest and love for the sport. So it is an area that is unstoppable. We know anytime it will be multi-facilitating. The example of boxing on image rights still. When we partnered with NBS Sport, our audience is the ghetto audience. You tell someone, don't hold a camera to record, my friend, you're going to punch each other. But then over time, we are streamlining and we are forcing them to TV. We force them. We are like, you know what, you watch on NBS Sport. Because we know that where we are going, it's going to be pay-per-view. And that is the outbreak of it, which is soon, 5 to 10 years from now. We call that soon. Timothy Kaja says he got a communication from ULS giving the date of the engagement with Parliament as 15th December. That is Thursday of next week, I think. He needs clarity on that position. Simon is online, but I know he's also busy. And I don't see the CEO.
Yeah, I think Timothy is right. Yeah, remember, yeah, 15th, yes.
All right. Then Timothy can take that on. It's 15th. I want to get closing remarks in the last 1 minute. The president has not also joined us. He had pledged to join us, but he's in an engagement, I know. He has not joined us, but my closing remarks, I think we need to liaise with the Law Society to see that we have a sports summit. Because I see everyone welcomes these presentations as great. We need a sports summit. We can start one locally and move ahead. Thank you. Ivan, your comments?
Let's fight for a proper sports law. I don't know what it will look like, but as far as I'm concerned, the two laws don't meet the standard yet. But let us continue fighting and advocating. There are small capacities. You never know, we shall have a proper sports law. But importantly, if we can, for starters, have a sports tribunal, we shall have one. That's my concluding remark.
Dennis, your parting shots.
Thank you so much. Always a great pleasure to appear here. And the one thing I can assure the lawyers who are there, Ivan mentioned it, I must be earning a lot of money. I started as a volunteer, and Philip mentioned it, 90% of people are volunteers. And one thing I can assure members, I've worked for 5 years, but there's no amount of salary really that can satisfy. But I believe when I leave FUFA, I would be able to do a lot of things in terms of sport. I expect to go be having knowledge in boxing. Now, when Ivan is suing a boxer, I'm able to defend him. When Timo is suing a federation, I'm able to defend. We go to CAS, we go to region. That's why our prayer is, let us invite other lawyers to come into the game. Because once somebody is sued, you need to get another lawyer to defend. Once you sue, you may find those of us who have started will always be the defendants and always advise clients accordingly. For the law, yes. Ivan, it's my humble request. Can we start somewhere? You know, once we have always hold Philip on some principles, once you want to be perfect, sometimes you never move. Since 1964, this is 2022, Kenya, East Africa, South Africa, England, these guys every month, I think they modify their laws depending on the trends. Because tomorrow you may find another area comes and then the regulation does not cover it up. If as society we can push to have something, we are not against the first bill, nothing about Magogo, we can harmonize our deal. Can we have something? Why do we have two FUFAs? Why do we have two athletics? Why do you have two? And then the law is really silent. So basically, those are my closing remarks. So Philip, we need to follow up and see how we can engage with other lawyers, young lawyers. Guys are doing well in oil, are doing well in PPAs, construction, something I've never heard of, but I've seen guys doing construction law. So I think if we are stuck here with time, we can't finish the business. The business is there. The start always not smooth, but I'm very confident the near future will be where I want to be. Thank you so much.
Simon has confirmed that the meeting is Thursday, 15th December at 10 a.m. Members, at 2 minutes past 1, I really thank you for dedicating your morning time to us for this discussion. When the flyers came out, I know the reception was quite less, but I want to assure you that we have hit a record number of about 150 people. I know some have not even logged in, but the attendance has been 150, which is very great. To young lawyers who want to open up their minds into different areas of practice, sports law and practice is one of those areas that is really interesting. I know Ivan Ojakol himself is into basketball. I already see him there. I'm into boxing. Dennis is into football, but we always liaise and discuss on several aspects of the law and sports. Thank you very much. We may not get a comment from ULS, but I believe it has been a great discussion. I see John Chris Kawesi has thanked the panelists and ULS for the great presentation. It is very enlightened. Thank you, Chris. Thank you to Singwire Emmanuel. Thank you, Nachiwala Sharon. Thank you, Mosubo Ayub. Thank you, Margaret Naiga. Thank you, Andrew Otim. Thank you, Claire Anena. Thank you, Chimoli Kotni. Thank you, Kibojana Richard. Thank you, Lydia Antono. Thank you, everyone. Asasla Athen, Egan Pamba, Agaba James, Waswa Fahad, Ernest Lutaya, Max Sinabulia. Thank you, everyone who has been Onoba Kenneth, Adupa Flavia Asime, Kunihira Wilfred. Wow, thank you, members. Thank you so much. We can live at peace. Please take use of Ivan Ojakol and Dennis Lukambi. These are very knowledgeable people. Kajubi Brian had to leave us because he had a court engagement. He's also very resourceful. He lectures sports and the law. I wanted to engage him so that we can have some short courses for our members. We can have 1 or 2 3-month courses in sports and the law just to enlighten and polish up.
Just for the record, I'm setting up something like that next year. I'll contact you. Don't worry.
Wow.
At International University of East Africa. So we're going to set them up.
No problem. Thank you. Thank you for the opportunity. I think members have had. These are things we can always engage in. I personally have like 3, 4. I think I have 4 studies in sports and the law. So I can always come in and members can always take opportunity. Pamba thanks us for the great presentation. Thank you, Pamba. Richard Barunji. Thank you so much, team. Members, we can leave at leisure. Simon. Ivan.